Lord's permission, Lord, may I make a mention. Lord, there's a case at item number 3, but there's a note which has appeared. I've been instructed that it is going to be taken up in the second half. My difficulty is I have a flight at 5 o'clock, Lord, because if it continues, we might not be able to. If it could be taken up pre-lunch.
Just a moment. Serial number 3. Then we start sharp at 2:15.
Lordship,
And,
in that case, Your Lordship,
yes.
we have informed the local council that our wing council, Mr. Ankita Purva, is not well, Your Lordship. So yesterday we have informed that we are taking time on this matter.
Were you informed about it?
Lord, I have been informed at around 8 o'clock in the evening, and I had already reached Ranchi. I'm coming all the way from Chandigarh.
Lordship, we are not aware about the senior council, Lordship.
No, last date also they had indicated, I remember, that some senior council is scheduled to come.
Lordship, the difficulty is
Lot
I don't
of cost
have the
involved
file.
in movement of senior councils.
Lordship, we are not aware.
And you don't need to inform the court? I have not received any intimation from your end that you are seeking adjournment.
Lordship,
That is not required.
no, Lordship. I have just got a phone call that he is ill. I'm not appearing on behalf of Lordship. He has
I
just
know, but it is not
requested
fair,
me to
no?
take time in this matter, Your Lordship.
When you are representing, you represent fully.
Yes, sir.
You can't represent partly, right? You
This
are
is
not
the
supposed to
difficulty which
inform the
we
court.
have informed them much evening itself.
So you take the court for a ride. We did your brief at the cost of other briefs.
Only because there is a medical explanation.
I appreciate fully. There is no reason to deny adjournment on medical exigencies, but you have some duty towards the court also. It can't be like this. So we can do one thing. We can hear you for some time,
Wait, please.
and then let us figure out the contours of your argument.
Yes.
Let them be there, and
That's
then
right.
we fix another date, and then we proceed accordingly.
Then my Lord is going to take it up at 2:15, right?
Not at 2:15 actually. We have a few more cases at 2:15. How much time will you take to give
Well,
the
if I-
contours of the case?
But for the contours of the case, I would take only 15 minutes.
Okay.
But if I have to
You
elaborate on
have
that,
your citations.
yes, my Lord, I do
The
have citations.
records have come.
The records, it's a pending matter, my Lord.
It's a pending matter.
That's right.
Okay.
It's a challenge to the reference which is being made.
All right. I didn't-
Amended reference.
Yes, amended reference, and
That's
your
right.
contention is that unless there is a fresh conciliation and
Apart from
method,
that,
etc.
it's not an industrial dispute. That is also part of my argument.
If it is not an industrial dispute, that could be a matter of consideration before the
Well,
labour
that
court
is right,
itself.
but this would go to the very root, and I would elaborate on that because the conduct of the party takes it out of the realm of an industrial dispute also.
Okay, you come at 2:15,
I will.
or maybe that we can do one thing. You come at around 1 o'clock.
Lord, I
Half
will.
an hour should be sufficient.
Yes.
You just listen to the contours of the argument, and you can ask Mr. Apurva to go and see the video. He will know what all are the arguments. Right?
Grateful.
So,
Extremely grateful.
that will be good enough.
Yes, sir.
1 o'clock.
Grateful.
Your units, serial number 9900, that's a RIMS units, and that is also promotion case. And we have filed in this in October, the case in October. Right now, the RIMS has advertised new advertisement, and that is for new recruitment.
Okay.
That will the petitions are serving more than 15 years in the RIMS.
You are seeking regularization. What are you seeking?
No, some of their colleagues have promoted. Some of the colleagues haven't promoted, and some have been left. And that is squarely covered with the judgment of activities units. So I filed an IA for
Pleadings are otherwise complete.
yes, we have filed everything.
You are for the petition.
Yes.
Who is for the respondent? You get hold of the respondent. You get hold of the respondent.
I know.
You can't mention a case out of turn without taking consent from the respondent. I am sure that serial number 99, they might not even have brought the file. You call him, and come back at 2:15. We will see what is to be done. Okay?
Leadership from within the list, serial number 74, only to the extent, my lords, that there was a direction upon JPSC for filing a counter affidavit long back in the year 2023 September. That has not been filed. If that may be directed again, my lord, and a date may kindly be fixed the matter.
74.
Yes, we have informed Mr. Sanjay people.
इसको कल के लिए कर दीजिए tomorrow.
जी.
74 or tomorrow.
And you.
Serial number 39 to 41 batch cases. All proceedings are complete, my lord. I have informed the respondent that this matter relates to the first JPSC exam 2006. Last occasion I was directed to file this squarely covered the Supreme Court two judgments. So that has been
I just want to know why are you mentioning
out of turn, my lord. 72 last time we mentioned करने से
2006 का रिक्रूटमेंट है, इसमें क्या urgency
ये अभी
है?
हमारा अभी 7 पोस्ट है.
आप अगर आइटम नंबर 1 भी टेकअप नहीं होने देंगे ना तो आइटम नंबर 2 भी नहीं पहुंचेगा, इसीलिए डोंट मेंशन लाइक दिस. We'll see when the case is taken up. You just
इसके बाद में वर्चुअस इसलिए हो जाएगा अभी 7 पोस्ट वैकेंट है. अगर वो फुलफिल हो जाए
आपको हो सकता है हम लोग पहुंच ही जाए.
हाँ तब तो देन
थोड़ा वेट करिए, आप कोर्ट को प्रोसीड करने दीजिए.
सीरियल नंबर 96 है
96 yes.
उसमें उन लोग अभी तक अभी भी नहीं जेडब्ल्यूएस फाइल नहीं किए. सारे वाइस चांसलर का इलीगल अपॉइंटमेंट है.
इसमें तो एक हम ऑर्डर पास किए हैं, आप देखे होंगे. इसी आइडेंटिकल मैटर में एक ऑर्डर पास किया, आप उसको देख कर आए. Right, because the JPSC has already taken steps. JPSC, the Honorable Governor has already taken steps to discontinue them.
इसमें जो
हमको जहाँ तक ध्यान है, आप PIL की तरह इसको नहीं फाइल कर सकते हैं ना.
और उसमें जो है जो चीफ सुप्रीम कोर्ट के जज छोड़ दिए,
कोई ऐसा अर्जेंसी नहीं है, ठीक है.
इन लोग पूरा कर लेंगे.
पूरा कर ही लेंगे तो क्या ही होगा. सब साइंटिस्ट लोग हैं, कौन से ऐसे सड़क पे बैठे हुए लोग हैं, राइट? दे आर ऑल एजुकेटेड साइंटिस्ट लोग हैं ना इसमें.
इनको
Am I correct?
10 साल प्रोफेसर का टर्म है, कोई प्रोफेसर नहीं बनेगा.
You are there in which
Serial
case?
number 52 and 53 is listed.
He has not yet completed. Please hold on
It
for a
may
while.
be heard for it.
Please hold on for a while. He has not yet completed.
कल परसों
आप
मेरा-
नहीं, ऐसा नहीं है, ऐसा कोई अर्जेंसी नहीं है. हमको पता है ये क्या मैटर है. हमने एक ऑर्डर पास किया है, उस ऑर्डर को देख कर आइए, ठीक है. पता करिए, एक ऑर्डर मैंने किया है इसमें एकदम
आज
आइडेंटिकल.
नहीं तो कल परसों में कभी रख दिया जाता है.
आप पहले ऑर्डर नहीं देखेंगे.
जी देख
हाँ, तो थोड़ा अपना होमवर्क करके आइए.
52 and 53 is listed today.
What is it?
It may be heard today.
52 and 53. What is the matter?
This is a matter where I have challenged the advertisement
Advertisement for
of home guard.
home guard recruitment. The recruitment is over.
No, still.
Counter affidavit file. Counter affidavit file. If it is not taken up today, you just come again and we shall see what is to be done.
Your next study supervisor. I met counsel, respondent counsel, Ashok Kumar Singh. I told you that he is not prepared, so take another date, any other date. He was submitted.
This is serial number.
9900.
The pleadings are complete as you say.
I have filed everything, and in fact, in one case they have filed contrary, but that's contrary not as per my petition. Right now, for the only
In 9900 को ना कल के लिए कर लीजिए, दोनों मैटर. The counter affidavit is not as per your requirement.
yes.
Okay, we'll see that. We'll see that aspect of the matter and then we'll see what is to be done. Till we call to.
This case item 1, criminal provision 300 of 2020.
On the last occasion, my lord was pleased to pass the order that Lord the case should be remanded back. In view of the order, Lord the judgment of the Supreme Court.
Petitioner argue.
नहीं,
Yes, क्या बोल रहे हैं आपको, क्या बोलना है?
नहीं ठीक है सीनियर क्या बोल भाई आप जो बोल रहे थे तो आई हैव गॉन थ्रू योर लॉर्डशिप्स जजमेंट बट दिस जजमेंट आई एम रिलाइंग अपॉन योर लॉर्डशिप दिस जजमेंट
Yes. आपने हमको दे दी.
जजमेंट है But the catch in this judgment is that I'll harp upon the first interim order of maintenance granted. I'll harp upon that. And one more indulgence I would seek from my senior, that the entire exercise be completed within 2 months. I am ready to
There is
cooperate
no
in
problem.
that may be.
Everything will be completed in 2 months. There
2
is no
months.
problem about it.
There's no problem
But
about
at
it,
the
madam.
same time, whatever has been fixed, you pay for 2 more months and it will be subject to final adjudication. It will be subject to final adjudication. There should not be any
No,
problem
no,
about
not
it.
at all. Not that.
So that's
It's a
it.
detailed that judgment I've read. It's a detailed judgment, so I will not say anything against that.
Because once
Okay. So
both the parties.
but 2 months not. But if
we
they
will,
should concede
you
to
see,
that.
I'll tell you one thing. I'll fix a date from here
Yes.
for filing of requisite affidavit by both the parties.
Yes.
Right?
Yes.
And on that day, you file your disclosures as
Yes,
per the
yes.
order of the
Yes.
Honorable
Ji.
Supreme Court, and that is why there is
Fair
so
enough.
much of discussion. That is
Fair
why I
enough,
have
fair
taken it out so
Fair
much.
enough. So it will not
Because
be required.
at times people are not
Yes.
reading the judgments properly,
yes,
so
yes.
the relevant extracts have been put in.
So fair enough. Not required.
And
to go
then
into
from
the-
that day, within 2 months, it will be
My lords,
decided.
I'll
How
go
much
back.
time will you take to file your affidavit? Yes, Mr. Kashyap? How much time will you take to file your necessary affidavit in terms of Rajesh versus Neha?
2 weeks.
2 weeks, that should be sufficient. I'll fix it
Yes,
right
yes.
from here.
Fair. It's fair.
I will not give much details
No, not
because
required.
this is
Not
covered
required.
by
Sufficient.
Is there only about the compliance of regarding filing or affidavit, that is.
That is the.
And last opinion, Bharat, please to.
And you
observe.
see, the parties are also prejudiced because the girl has not disclosed her affidavit.
Yes.
And
You know
she is
that-
an educated lady, so her disclosure is also
Yes, no,
equally
that is the
important.
requirement as per the judgment passed by the Honorable Supreme Court.
Yes. And marriage is
So-
not in dispute,
No.
right?
Yes.
Those things are not.
My lord, we fix a date, my lord.
I'll fix a
And
date,
In the
you just-
meantime, Lord, the amount, Lord.
No,
is
that
9.
will continue to be paid. I have already
But
disclosed.
there is one more issue. There was a stay passed by this honorable court.
No,
That
we will
period-
take care of that.
That period I'm not going to pay because there was already a stay. What they have done is, but there is a stay already by this court. I will not go on that point. Despite getting it removed from this court, even after passing of that
Will you
Asian
one
resurfacing
thing, at
case,
least current maintenance?
My lord, the
Current
maintenance that
maintenance
is due,
should be
Lord,
paid.
is 11,70,000.
You
For
see,
that, Lord,
but there was a
Just,
stay.
just a moment.
There was a
Just
stay.
moment. Just a moment.
Only
Mr.
district
Kashyap,
court,
Mr.
that-
Kashyap. The interim arrangement will be only to ensure that you are not prejudiced in any manner, right?
Yes.
This
Yes,
is not
that
this is not a premium on, it is not a method of recovery of money. Basically, your sustenance is to be taken care of.
applies to-
So current maintenance you
Yes.
give,
I agree.
right
I
from
agree.
this particular month, you
Yes, ma'am.
remit the maintenance amount.
Yes.
And then it will be decided in 3 months' time. And as per the judgment of the Honorable Supreme Court, it will relate back from the
From the
Yes,
date
value
of
the
no,
application.
that can be.
And the disclosure, to all fairness to both of you, should be right from the in not only in terms of the judgment of the Honorable Supreme Court, but also your current.
Current has to be.
Yes, current also has to be, because there could be a possibility that she has now been engaged. Quite possible.
That Neha judgment takes care of everything. The
Yes,
subsequent also, that's why we had filed an IA application.
that's so
disclosing
everything will be
Everything.
taken care of,
Everything.
and I'll fix a date right from here. It
And
seems
2
that your
months.
clients are here. Whose clients are here? Your clients are
Yes,
here.
their clients are.
Okay, so it is being passed in their presence only.
Yes,
They are here to listen to that.
2 months, Manoj.
I will give you.
I'm so deeply.
No problem. What is the date of Rajesh versus Neha?
The date of Rajneesh versus Neha is 4th of November 2020.
4
November 2020.
November
I'll pass on the judgment.
20. Because I have
Your
to take
judgment
care
takes-
of this, that
Yes,
the
yes,
judgment
your-
is.
Yes, your
up.
judgment has taken care of every aspect, every nook and corner of that particular judgment. And this is a order where both of us have agreed, in fairness, because this is the Supreme Court's.
And there is, Lord, in the judgment also, in the pending cases, Lord, it is required.
It has to be required. That's why there was an order of this Honorable High Court to file before this High Court itself, and that we did it. But anyhow, now we'll go to the court below and we'll file it.
You see, this judgment is, the impugned judgment is prior to Narjis versus Neha. That is 19th of February 2022.
That's why when this Honorable High Court had passed an
Yes.
order for
That's
That's why I was trying to, but you also
because
said, okay, you go to
there
the
is
court
no
below.
proper disclosure of the income of the wife
Yes.
as I see
Yes,
it in the
yes,
order,
yes.
and therefore for that purpose that is required to be done.
Yes, yes, yes.
Which is that order by which appropriate direction was passed.
Both below spouses are required to file their affidavit to that
The
extent.
order of this
Yes.
Honorable High Court.
17th November 2021.
Yes.
17/11/2021. लिखिए. Criminal Revision number 300 of 2020. Learned counsel for the parties are present. Kindly give your appearances.
Certainly.
This petition has been filed challenging the legality, propriety and correctness of the judgment dated 19/2/2020 passed by the Learned Court of Principal Judge Family Court Ranchi in original maintenance case number 03 of 2019, whereby the Learned Family Court has been pleased to pass an order directing the petitioner to pay a sum of rupees 45,000 per month to the opposite party number 2 to be effective from the date of the judgment.
It is 19.
The learned counsel for the parties have submitted that the impugned judgment dated 19/2/2022, though passed prior to the judgment of the Honorable Supreme Court in the case of Rajneesh versus Neha reported in bracket 2021 bracket close 2 SCC 324 dated 4th of November 2020. However, this court-wide order dated 17/11/2021 had directed the parties to file their required affidavit in terms of Rajneesh versus Neha. They submit that the affidavit has already been filed before this court, but both of them are not satisfied with the affidavit filed by each other.
They have not come. We have
Okay.
we have filed an IA application for 340 making. But I'll not go there. I'll let the lower court decide.
Just a moment. The learned counsels have jointly submitted that there is a serious dispute with regard to quantum of maintenance, and the opposite party number 2 is the wife of the petitioner,
G.
and she is also highly educated. The learned counsel for the petitioner has submitted that there was no disclosure of income of opposite party number 2 before the learned court below, and it cannot be assumed that she did not have any income. He has submitted that the quantum of income is to be determined in accordance with law, and even though in the judgment passed by Honorable Supreme Court in the case of Rajneesh versus Neha, the affidavit was required to be filed in all pending cases, but in view of the order dated 17/11/2021, as well as the nature of dispute involved in the present case, the matter is fit to be remanded to the learned court for fresh consideration of the affidavits of the respective parties. He submits that he is ready to file the required affidavit in terms of Rajneesh versus Neha before the learned court below within a period of 15 days from today.
But should I fix a date?
I'll fix a date. He submits that a date may be fixed by this court. The learned counsel appearing on behalf of the opposite party number 2 has submitted that he has no objection if the matter is remanded for fresh consideration, but the maintenance which has been fixed by the learned court may be continued to be paid so far as the current maintenance is concerned, so that no prejudice is caused to the opposite party number 2 while conducting the case. He has also submitted that the impugned order of granting maintenance from the date of the judgment itself is not correct in view of the judgment passed by the Honorable Supreme Court in the case of Aziz versus Neha, which says that the maintenance has to be awarded from the date of filing of the application. The Learned Counsel has submitted that the maintenance may be continued as interim maintenance subject to the final result of the case before the learned tribe.
It's a distress warrant they have got
Just,
issued against.
we'll take care of it.
My lords, my lords.
At this, the Learned Counsel for the petitioner has submitted that there is a distress warrant issued against the petitioner. He has also submitted that the interim maintenance also be made subject to the final result of the case. He has further submitted that some time frame of about 2 months may be fixed from the date of appearance of the parties so that the matter is ultimately taken to a logical end. The Learned Counsel has also submitted that the Honorable Supreme Court has also indicated that in case of false affidavits being filed with regard to disclosure, a proceeding under Section 340 of CRPC may also be initiated. I'm just indicating such that the parties know about it.
Yes.
That
that's-
there is a
yes,
serious.
Yes, yes, yes,
It is applicable,
Like-
applicable to both. the
both,
parties.
yes.
Yes, it is applicable
Yes.
to both the parties.
Yes, yes.
After
Fair.
hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that the marriage between the parties is not in dispute. This court also finds that both the parties are highly educated and at the time of marriage were having their independent source of income. However, it is the case of the opposite party, number 2, that on account of the illicit relationship of the petitioner with a third party and the fact that they were living at different locations, the marriage was not working out well, and on account of this, she was forced to come back to her parental house after leaving the job. And she has been staying at Dhanbad?
No, no.
Staying at
They can say, not
In
the case of.
Dhanbad?
No, no, it's not a case of.
She
Dhanbad, it's a case of
lived in
Ranchi.
Ranchi along with her father.
Living in Ranchi along with her father. This court finds that before the learned court, the true disclosure with regard to the income of the parties has not been brought on record. The opposite party, number 2, had not disclosed her income on affidavit, nor her income tax returns, etc., were filed before the learned court. However, the petitioner had filed certain documents, but the same also appears to be incomplete disclosure of the
According to opinion, that
assets.
is not correct.
That's right. But the said disclosure was also not complete in all respect, and both the parties are fighting on the point of quantum of compensation. In view of the fact that the parties are fighting on the quantum of compensation, and also the fact that the obligation of the husband to maintain his wife cannot be disputed, but at the same time, the maintenance has to be quantified in accordance with law. Accordingly, this court is also of the view that the quantum of maintenance cannot be fixed by this court in revisional jurisdiction. Accordingly, the impugned order dated 19/2/2020 is hereby set aside only with regard to the quantum of maintenance, so that the matter is taken up afresh by the learned court, so that and the quantum of maintenance be fixed in terms of the judgment passed by the Honorable Supreme Court in case of Raziz versus Neha Supra. The parties are directed to appear before the Learned Family Court, Ranchi?
Yes.
Family Court at Ranchi on 30th of April, on 30th of April 2024, along with their affidavit in terms of Raziz versus Neha. I will just put it all the enclosure etc.
Right.
There will be certain modifications. Since your clients are there, I should indicate there will be certain modifications with regard to the observations of Raziz versus Neha. And upon their appearance, the Learned Court is directed to pass appropriate orders in accordance with law with regard to quantum of maintenance after giving due opportunity to the parties concerned within a period of 2 months from the date of appearance.
From the date
2
of-
months
नहीं,
from-
आज
from
से
the
कर दिया है because we both are agreeable to
yes,
it.
Lord.
We both are agreeable to it.
From today.
Okay.
From
can
today
be-
I just 30th April है ना, तो by 15th of June,
Okay.
2 महीना तो हो जाएगा. आज 15 तारीख है.
3 महीना खींच लिया.
हाँ, डेढ़ महीना से।
3 महीना खींच लिया.
कैसे जोड़ते हैं पता नहीं मैच अप्रैल के बाद मई और जून
मैच कमजोर है.
सुनिए, ऐसा है कि जैसे ही जून लग जाएगा, इट मेक्स नो डिफरेंस इट इज 15th of June or it is 30th of June. जून तक का तो आपको मेंटेनेंस देना ही
We have
पड़ेगा.
a chance before my lords on the lighter side. It was just lordship is the final say for us.
So
And
by
everything.
14th of June,
My lords.
by 14th of June,
Certainly.
the parties, the council for the parties have undertaken to extend all cooperation
My
before
lords.
the Learned Court for the disposal of the matter in terms of the directions by this court, considering the fact that although there are arrears in connection with maintenance, however, since the matter is being remanded for fresh consideration on quantum of maintenance, it is hereby directed that the petitioner would continue to pay current maintenance amount of rupees 45,000 per month to the opposite party number 2 for the month from April 2024. And the same would be subject to final adjudication by the Learned Court on the quantum of maintenance. The current maintenance be remitted to the account of the opposite party number 2 within a period of 1 week from today. अभी का अप्रैल का, मई का, जून का
दे देंगे.
निकाल
अप्रैल में
लेंगे.
जून का 3 तो हमको देना होगा.
ठीक है. अकाउंट नंबर होगा.
है.
कितने elite क्लास है, आप क्या
नहीं वो कोई नहीं. That is a very वो ये thing will certainly do that. और वो मेरा distress warrant.
हाँ. Considering the aforesaid facts and circumstances, the distress warrant को set aside करना
हाँ कोई
पड़ेगा.
supervisor should be हाँ satisfied.
तो लिखवा दो।
The distress warrant issued against the petitioner on account of non-compliance of the order passed by the Learned Court on account due to non-payment of the maintenance is hereby set aside. Up to, I'll tell you one very important thing which is happening is that in Rajiv versus Neha, you have to disclose your bank account. 125 में the most important thing is the execution. वही नहीं हो पाता है. Once that disclosure of the bank account is there, execution has become easier.
Execution is very difficult.
Now it has become easier ना. Bank account detail रहेगा तो तुरंत attach हो जाएगा.
जो जिसके पास पैसा नहीं उससे difficult. Otherwise people with bank accounts. they
Well,
are
now
so-
the bank account details are required to be
Yes,
disclosed
yes, furnished,
as per
yes.
Rajiv versus Neha also.
my PAN, my bank account, my Aadhaar, everything is before the court. So a person
कुछ सेटल नहीं करेंगे क्या आप?
settle हम चाहते हैं, हम तो बहुत
You are not
sir
interested.
अगर if the
Your
senior
party is not interested.
senior
in any
अगर
kind
थोड़ा
of
सा वो
settlement.
ले ले because both are in
हम
there.
हमको
Call him if that lady is there.
There is
Caller,
She also will not
caller if
they
she
do
is
not
there.
have a
Pardon?
child.
Caller
also.
if she is there.
See here.
Call her please. Yes, please come.
Father.
अच्छा
उनके
call.
father brother.
अच्छा
Sorry brother.
उनकी माँ को
बड़ा-
बुलाइए. Yes, please.
No, they are both of them. No child also.
We have also tried our level best, but
Let's figure it out.
there is no chance.
नहीं, there can be sir. लोग चाहे तो.
Yes, madam. Please come. Is there any likelihood of settlement between the parties?
यस हम तो चाहते हैं सर कि मतलब सेटलमेंट नहीं हो, सेटलमेंट नहीं चाहते हैं बेटी, हम भी नहीं चाहते हैं।
Separation चाहते हैं?
नहीं सेपरेशन नहीं चाहते, मतलब सेटलमेंट मतलब साथ रहे।
साथ रहना चाहते
जी,
हैं ना?
जी, जी।
आपकी बेटी चाहती है ऐसा?
चाहती हैं बट जानते हैं मैम अभी मेंटेनेंस का जो मीडिएशन हुआ था रांची कोर्ट में, तो लड़का साहब बोलता है कि तुमको नौकरी छोड़ना पड़ेगा, साहब बोलता है। और मीडिएटर मैम भी तबाह हो गई, उस समय कुछ बोलता है 4-6 महीना चला मीडिएशन, 3 महीना जो कि 3 बार होना चाहिए, 6 बार मैम करवाई। उसके बाद बोलता है कि तुमको हम घसीटेंगे कोर्ट में, देखो हम तुमको
My
घसीटेंगे।
the
नहीं,
father.
कोई बात
they
नहीं,
what-
ऐसा-
I'll just such a truth which she is saying. The father is also working. He has been made an accused. The mother-in-law, they are an accused. Everybody. We have time and again said that we are ready to settle. Wherever she wants to work, she can work. We have no issues. We have no issues at all. But
चलिए
सर चाहते हैं मैम तो हम इतना दूर थोड़ी आते केस में, अगर हम नहीं चाहते हैं
कोई बात नहीं.
My lord, may
कि शांति
Yes,
my
से
lord, may
yes.
indicate in the order, if my lord so pleases, that not the very chance of compromise between the parties, not the court may perform. If my lord so pleases, otherwise this is my charge. Otherwise, not
they
the
prolong
this
this.
matter.
That will देखिए 2 महीना का ऑर्डर हुआ है ना,
जी.
Let it
इसको
come.
फिर वो गड़बड़ हो जाएगा.
Let it come.
वैसे तो आप जॉइंटली अगर फाइल करेंगे तो झालसा में आ सकता है. झालसा इज वेरी गुड मीडिएटर्स वहाँ पर.
ये तो जैसा मदर का भी स्टेटमेंट है, जैसा आपको
नहीं ऐसा है सर, देखिए डीएलएसए में हो सकता है उतना बढ़िया से मीडिएशन ना हो रहा. झालसा है ट्रेन
मैम
मीडिएटर्स.
झालसा में भी करवाए हैं, संजय सर करवाए थे झालसा में।
कुछ कहना चाहते हैं.
हाँ जी बोलिए.
एक्सक्यूज मी मैडम, हम उसके फादर हैं और झालसा में भी यहाँ से गया था मैटर सेटल करने के लिए, तो उनकी माँ बोलती है कि आपकी 3 बेटी है, एक बेटी की दीदी पर आपको अब क्या हुआ? अब
सब
बताइए,
चीज ये सारी चीजें जो है ना,
बेटी होना कोई गुनाह है क्या?
ऐसे
They are government servants. They are at Patna. They have absolutely nothing to do with the family. They have been
कोई
pulled.
बात नहीं है.
They have been unnecessarily pulled.
देखिए लाइफ जो है ना दोबारा तो नहीं मिलती ना.
जी सर, जी
That
मैम।
is what we are trying.
मैं
They
खुद
they
समझ
want to
रही हूँ।
litigate. They
As a
want to
mother,
litigate. But I am not
एक
alleged
चीज और
against them.
लिखिएगा, the learned counsel for the petitioner has relied upon the judgment passed by this court in criminal revision number 217 of 2022. आपका रिलायंस है ना?
हाँ हाँ.
हाँ. ठीक है.
That is
इसी में से
the
कुछ
that is the judgment on which everybody has to rely.
ठीक.
Because that is the.
There will be certain modifications in the judgment. I'll just cull out certain portions, but date has been fixed for your and it will be decided in 2 months.
Well, both the
और एक
parties.
चीज और है मैडम, it is not necessary, you see these are all educated children, right? It is not necessary कि रहने की ही बात हो, कभी separation की भी बात होती है, because they have to lead their life. अगर मान लीजिए नहीं वर्कआउट करता है तो you can think, we do not know, it is absolutely for you to
मैडम,
decide.
excuse me, मैडम, शुरू से ये लोग यही कंडीशन लगा रहे हैं कि लड़की को नौकरी छोड़ना पड़ेगा. वो पढ़ी लिखी क्यों है? आप पढ़ी लिखी लड़की शादी क्यों करवाए आप? क्यों छोड़ना पड़ेगा नौकरी?
कंडीशन रखे, 4
क्या
कंडीशन
कंडीशन
रखे।
आपका सर? मैडम क्या बोले आपको? हम लोग दुखी हो गए ना पूरा उन लोग से. ऐसा सब बात लोग बोलता है.
Disposal कर दीजिए.
Unjust enrichment case. Unjust.
IA closed. Both the IAs closed.
But
For order contained, Dolippius 255 of 2023.
Yes, petitioner. Who is for the petitioner in this case? WPS number 255 of 2023. Counsel for the petitioner is absent. Goes tomorrow. कल एक chance और दे देते हैं.
Item 11, WPL 1918 of 2023.
Yes, petitioner. Mr. A.K. Mehta was appearing for the respondent in this case. And where is the petitioner? Yes, Mr. Amit Kumar, are you there? Where is the petitioner? Mr. Lalit Yadav. In this case, notice was issued to the union who had espoused the cause. So they are just pro forma party. LCR has already come. Yes, this can be decided. Are you ready?
Yes.
Where is Mr. Yadav? हाँ उनको जरा बुला के लेके आइए. उनको तो नोटिस सर्व करने का कोई पर्पस ही नहीं है.
Yes.
Right? Pass over.
Item 12, WPS 2710 of 2023.
आप ठीक से बोर्ड में कर रहे हैं. Respondent is also not there. Are you there for the state? Pass over.
Item
पास
13,
ओवर मैटर्स नोट डाल दीजिए 12:30 बजे.
In this case,
Item 13, WPS 4309 of 2023.
in this case, because notices had been issued to the private respondent because the private respondent had claimed for the family pension because, and because of which because the JUVNN has taken a decision to stop the pension of both the plans.
There is a serious dispute.
So far that part is concerned, Milos
You
will
go and get your succession.
Milos, one thing Milos will appreciate that the PPO has been issued. Milos, the PPO Milos will appreciate that the family pension is included in the pension payment order itself. Milos, the pension payment order is in my favor. Milos.
No,
And there
whatever
are-
it is, once there is a very serious dispute and there is a judgment of some court, criminal court,
Milos,
regarding marriage,
Milos.
and there was a second marriage by saying that you are the second wife.
Milos, so far.
So we appreciate that you are not a party there. We appreciate, but once there is a dispute as to who is the first wife,
Milos will
there has to be a succession certificate in order to.
Milos, to that extent, but Milos, I respectfully submit Milos. Milos will appreciate once the Milos, I am the Milos wife because my name is there in the pension payment order. The
See,
PPO
we do
Milos,
not know. You see how the husband has conducted himself. We do not know.
Milos, as
It is quite possible that he omits to give the name of his first wife and gives the name of his second wife.
Milos,
But that will not defeat his rights. Therefore, a succession certificate.
Milos, she is being paid Milos pension at the rate of some Milos maintenance at the rate of 3,000. That is also being deducted from the family pension also Milos.
Who is being paid pension?
Milos, the respondent number 4, Milos, the private respondent, the other wife Milos.
Under what provision?
Milos, under the Milos 125 maintenance act, she had filed her Milos case which in the order.
So therefore, a succession is required. A succession is required.
Milos, what I submit Milos because
No,
the
it can't
ladies
be
Milos,
decided.
ladies all.
We appreciate that. Ladies are there. They are fighting with each other.
They are
could
almost
be,
Milos on the verge of starvation Milos 1 month, 1
For
year
that-
Milos, almost a
for
year
that go
Milos.
to Jharkhand.
That is the whole issue Milos.
Who
Otherwise
is
I
there
would
for
not
the
have
private
pressed.
respondent? Are you appearing?
Milos, the notice have been issued Milos, she has not entered appearance.
Forget it. You just get your succession certificate.
Because Milos, the PPO Milos
I'm only on to one point, my lords.
We appreciate it fully, but
Pension
succession
payment order,
would
my
take
lords,
time.
includes the family pension payment order also.
Everything,
The family pension order, my lords, authorizes me.
Yes, yes.
So
But once there is
in
a
view of the
dispute,
proper my lords, nomination of me as a nominee, my lords.
you see, husband is nominating MSX,
Yes.
but you do not know what is the legal status of MSX.
So far that part is concerned, my lords, there are series of my lords, documents, unimpeccable in
Document
nature.
disclosure by the husband will
Not
be
disclosure by the
sufficient.
husband, even by there is a finding by the court, my lords, that I am the wife of the my lords, concerned person.
There is a finding by
The first
criminal
and the
court
first
also.
and the first wife, my lords, that is the finding by the competent court of that I am the first wife of this.
Where is that finding?
My lords, may kindly have
No,
it.
you have this finding in criminal revision.
My lords,
have the finding in the
my lords, the
criminal
criminal
case.
revision, there had been a series of litigation going on in between these parties also, my lords.
Exactly. WPS number 4309 of 2023. Are you for JUVN? The Learned Counsel for the petitioner and respondent number 5 are present. Who appears for the other? Respondent number?
Except for 4 minutes, all the will be appearing.
Okay.
1, 2, 3.
The Learned Counsel for the petitioner and respondent number 1, 2, 3 and 5 are present. Nobody appears on behalf of respondent number 5, respondent number 4, in spite of issuance of notice and as per office note, there is no service report and therefore the matter has been posted for orders. However, considering the facts and circumstances of this case, this case has been filed for the following relief. The Learned Counsel for the respondents has submitted that the petitioner and respondent number 4 are in litigating terms in view of the fact that that each one of them claimed to be the first wife of the ex-employee. The Learned Counsel has submitted that the pension was being paid to the petitioner, but the same has been discontinued on account of findings in a criminal case wherein it has been recorded that the respondent number 4 is the first wife and the petitioner is the second wife.
One submission of mine to the extent that there are other judgments also of the different forums where I have been admitted as the first wife. Even the deceased has admitted me as the first wife. Those are on record itself. I'm not going beyond it.
The Learned Counsel, at this, the Learned Counsel for the petitioner has submitted that there are other orders passed by different forums wherein the petitioner has been declared to be the first wife.
And she was nominated by the
ex-employee. And accordingly, the pension order as well as family pension order has been issued in favor of the, and consequently the family pension order has been issued in favor of the petitioner. The Learned Counsel has also submitted that so far as the opposite respondent number 4 is concerned, there is an order of maintenance in her favor and an amount of rupees 3,000 per month was being deducted from the salary of the ex-employee throughout and is also being paid from the pension. After hearing the Learned Counsel for the parties and considering the nature of dispute involved in the present case, there are certain orders in favor of the petitioner and certain orders in favor of the respondent number 4 with respect to their status vis-a-vis the ex-employee. However, in none of the proceedings, both of them are parties, except the present recognition.
That is true.
This court also finds that even as per the petitioner, there is an order of maintenance in favor of respondent number 4. In the aforesaid facts and circumstances, this court is of the considered view that the dispute between the petitioner and the respondent number 4 cannot be decided in writ jurisdiction, and it is for either party to get a succession certificate from a court of competent jurisdiction. It is also important that in the succession case, both the parties, both the petitioner and the respondent are required to be made party, so that the interstate dispute between the same is ultimately resolved and comes to a logical end. This court is of the view that the question of continuation of pension in favor of the one or the other party will arise only upon receipt of an order passed in the succession case. In view of the aforesaid facts and circumstances, this court is not inclined to interfere with the order passed by the respondent on the point of stoppage of on discontinuation of pension in favor of the petitioner. Let a copy of this order be sent to, office is directed to send a copy of this order to respondent number 4 through speed post. ठीक है? ये काउंटर एफिडेविट अभी फाइल हुआ? पहले से फाइल हुआ?
पहले से।
ठीक है, चलो. This should be sufficient?
Yes.
For press filing item 14, WPS 285 of 2023.
Just wait for 1 week time.
For what?
Just a 1 week wait. Next week.
इसलिए आपको टाइम चाहिए बताइए.
पूरा तैयार नहीं हो पाएंगे.
Counsel for the petitioner seeks adjournment. Nobody appears on behalf of the respondents. Are you there?
I need to invoke a state case.
Counsel for the respondent state is present. Pose this case tomorrow. कल सुनिए.
अब
Item 16, WPS 2944 of 2023.
Yes.
Asking for
Some consultant.
consultant fees.
Yes.
Jharkhand State Livelihood Promotion Society.
So, you file an affidavit, you pay the admissible dues. If there is any dispute, we do not.
He's worked under the society. The society would not be taking notices need to go to the society.
You are not representing the society. Then the writ petition would lie against the society.
If it is under the rural development department,
Yes, are you there for the petition? Yes. What is your case?
This matter belongs to Lordship.
Learned counsel for the parties are present.
To make payment, outstanding payment of rupees 1,30,3,018 Lordship. At the interest rate of 18%. Pre-litigation was there, Lordship. Before this, pre-litigation was there, happened, Lordship.
Where is that detail?
Next in Lordship. Page number 25 onwards. Pre-litigation was failed, Lordship. That is why we have come here.
Issue notice to respond number 1, for which requisite under speed post be filed by day after tomorrow. It's a preemptory order, you file your requisites. Speed post as well as ordinary process. The learned counsel for the respond number 1 and 3 is also directed to seek instruction and file a counter affidavit in the present case. By filing the counter affidavit by respond number 2 and 3, 2/3, the admissible amount, if any, be paid to the petitioner. Right? Pose this case on 8th of May 2024 in the supplementary cause list. The counter affidavit be filed by latest by 6th of May 2024. The notice should accompany a copy of this order. Admissible amount है pay कर दीजिए, dispute पे we will not enter. तो उसके बाद बना प्रेम्प्ट्री ऑर्डर आपका डिसमिस हो जाएगा ना तो रेस्टोर भी नहीं करेंगे, ठीक है?
Item 17, WPS 3463 of 2023.
Yes.
Appear on behalf of JPSC. On the behalf of JPSC for the
File a contract. I think this is, they were supposed to attend that medical.
No, not the medical, this is in relation to LBP examination, rather he had submitted a caste certificate of DC1 training of BCP. It's a mistake which was there.
Okay, you file your contract.
I'll file.
Nobody appears for the petitioner. However, the respondent number 3.
3 days.
The counsel for the respondent number 3 is directed to seek instruction. Respondent number 2 is directed to seek instruction and file a counter affidavit in the present case. No notice need be issued at this stage to respondent number 3. Let the counter affidavit be filed by 29th April. Post this case in the supplementary cause list on 30th of April.
Item 18, WPS 3716 of 2023.
You also disclose the cut-off marks, etc. Yes, petitioner.
My lord, in this matter, petitioner paid for consider the case of the petitioner in respect of revision of family pension with effect from my lord 1/2006 and my lord 1/2016. The counter affidavit has been filed. The family pension has not been revised, and my lord, the letter has been sent to my lord AG. So my lord, direction be given to my lord the treasury officer and the AG to done as per my lord direction of DSC Rambar.
Where is that letter?
Will addition,
Yes.
as per our legal instruction, revised pension has already been granted.
Or the counter affidavit has been.
Just a moment. So according to you, the grievance of the petitioner has been redressed.
According to our
If there is any arrear, you ensure payment, and if they have any further grievance, then they will be present.
Yes.
That should be sufficient. Respondent number 2 will take care of that.
Or the respondent number also.
5.
5.
5 and 6. 5, 6, madam. 5 and 6.
Why not respondent number 11?
Yes, sir.
Who's the best person? Respondent number 11.
11 is not behalf of the retired.
No, respondent number 11 is. Oh, sorry, no.
10.
Respondent number. No, not 10.
10 and 11 behalf.
Respondent number 3 should take care of that.
3, madam.
Respondent number 3, Director,
Primary.
Primary Education, State of Jharkhand. Right. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the respondents has submitted that a counter affidavit has been filed by District Superintendent of Education, Ramgarh, wherein a stand has been taken in paragraph 12 that the grievance of the petitioner could not be redressed because of non-availability of service book, and quick action has been taken by directing for payment of to open a second copy of service book by letter number 392 dated 15/3/2023. And the District Superintendent of Education, Ramgarh, by letter dated 3/10/2023 has sent the service book of the petitioner's husband along with hard copy of online application for revision of pension/family pension to Auditor General, Jharkhand, to issue revised pension/family pension authority letter. The learned counsel for the petitioner has, the learned counsel for the respondents has submitted that as per his oral instruction, the grievance of the petitioner has been redressed and revised pension payment order, family pension order?
Yes.
Family pension payment order has already been issued. Upon this, counsel for the petitioner has submitted that he is not aware about the up-to-date development, but if revised pension order/family pension order has been issued, then the petitioner would be entitled for arrears. And therefore, appropriate order may be passed so that if there is any surviving grievance, the petitioner may approach respondent number 3, right? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and the argument advanced on behalf of the respondents in the light of the counter affidavit filed by the District Superintendent of Education, this court is of the considered view that no useful purpose will be served by keeping the present case pending. If the petitioner has any surviving grievance in connection with pension order of her late husband / family pension order with regard to herself, she may raise the grievance with respondent number 3, who shall ensure that the admissible amount payable to the petitioner is paid at the earliest but not later than 3 months from the date of communication of this order along with the representation which may be filed by the petitioner. Sufficient? This petition is according to this petition.
Item 19, WPS 3803 of 2023.
But this is retirement, grant of retiral benefits matter to the petitioner. Counter affidavit has been filed, and in para number 8 to 11 of the counter affidavit, but they have said that the case of the petitioner is squarely covered by the notification dated 12/8/2023, and they are also ready to extend the similar benefits to this petitioner. Lord, it's a covered matter. The coordinate bench of this honorable court, my lord, has already passed, my lord, similar orders, my lord, for other employees.
My lord, will kindly see my lord's paragraph 10 of my affidavit, my lord. We have, my lord, said that the matter has, my lord, the concerned file of the petitioner has already been sent to the finance and the law department for, my lord's concurrence and waiting. So, my lord,
How
this
much
is
time will
admitted.
it take to
My lord,
complete the process?
my lord, at least 6 weeks, my lord, because after this Lok Sabha election, this matter.
That's right.
It's square covered matter
तो
also.
बोली admit करे भी है.
Or admitted. Similar types of counter load in that case also with similar admits.
कौन सा है?
Same department.
The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has the learned counsel for the respondents has referred to the counter affidavit and has submitted that the matter regarding the claim of the petitioner has already been processed and the file has been sent to the finance and law department for concurrence and vetting. He has also submitted that a statement has been made in paragraph 8 that necessary steps is being taken to expedite extending similar benefit to the petitioners in the present case as has been in terms of the resolution contained in memo number 900 dated 12/8/2023. At this, counsel for the petitioner has referred to order dated 17 February 2024 passed in WPS number 5180 of 2015. And submits that similar order may be passed. After hearing the learned counsel for the parties and considering the counter affidavit filed in the present case, it is not in dispute that the petitioner's husband was the employee of Bihar State Road Transport Corporation and was posted at District Transport Office, Divisional Manager Ranchi, and he superannuated on 31/3/2009. And as per the counter affidavit, the admissible retiral dues was already paid to the petitioner's husband. However, it has been stated in paragraph 7 to 10 of the counter affidavit as follows. It has been stated in paragraph 7 of the counter affidavit that the claim for regularization from 1/7/2004 and for providing admissible retiral dues has been considered while an appropriate resolution contained in memo number 900 dated 12/8/2023 has been issued, and the concerned file has already been sent to the Finance and Law Department for concurrence and dating. Paragraph number 6 to 10 of the counter affidavit are fulfilled as under. In view of the specific stand taken in the counter affidavit, no useful purpose will be served by keeping the present case pending. The respondents are directed to take appropriate decision in connection with the claim of the petitioner within a period of 8 weeks from today, and the admissible amount be remitted to the petitioner within a period of 2 months thereafter. This petition is accordingly disposed of.
Your Lordship, at serial number 17, Your Lordship, I was not able to complete Your Lordship. I've got direction to file a counter order, Your Lordship.
I will not record your appearance.
Item 20 WPS 3840 of 2023.
आपके एडवर्स ऑर्डर नहीं किए ना?
Yes, Your Lordship.
You be happy with that.
Apply.
Yes, petitioner.
We not simply pass on.
Pass over.
Simply.
This will be taken up. आज ये कल पे नहीं जाएगा. 12:30 बजे आ जाएगी.
Item 21 WPS 4048 of 2023.
Who is for the respondent?
Same.
ये जरा CMPF Act में. They have a remedy under CMPF. Are you not aware?
In this petition, they have challenged the calculation of their pension, fixation.
So they have a remedy under the Act. Yes, Counsel, do you have a remedy under the Act? I can't hear you. Please. Yes, you have a remedy under the Act or not? Yes, 7B. दीजिए भेज. उनको दीजिए सेक्शन. किताब लाने से कोई मतलब नहीं है, पढ़ने से भी कोई लेना देना नहीं है. You are appearing for CMPF?
Yeah.
You are not aware about the Act? Is it a remedy under 7B? If there is any, do you have a remedy under 7B of the CMPF Act? Is it the same Act? बताइए. Counsel, I can't hear you. आपका इंटरनेट काम नहीं करता. आप रांची में हैं कि रांची के बाहर हैं? आपकी आवाज नहीं आ रही. Yes, you have a remedy under the CMPF Act. You move the authority. They will quantify if there is a calculation error. JIT में क्या होगा? यहाँ पे 2 + 2 4 तो हम लोग कैलकुलेट नहीं करते हैं. I will give an observation. 7B में you have a remedy, right? Is that okay?
Yes.
According to my calculations, the petitioner should be given 21,704 rupees, and instead representation after representation has already been given.
You will move which authority? Tell us. Respondent number? 5. Respondent number 5?
5.
Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the monthly pension of the petitioner has been wrongly fixed at rupees 18,958 in place of 21,704.92. And therefore, and in spite of representations, no decision has been taken. The learned counsel for the respondents has submitted that petitioner may move respondent number 5, who would be the appropriate authority to look into the grievance of the petitioner regarding calculation. Considering the aforesaid facts and circumstances and the fact that the dispute is regarding quantum of pension payable to the petitioner, this writ petition is disposed of, enabling the petitioner to approach respondent number 5 by filing a petition along with a copy of the writ records, and upon filing of representation, the respondent number 5 shall pass appropriate reasoned order after granting an opportunity of hearing to the respondent CCL. CCL का कौन जाएगा वहाँ पर? Which authority of CCL will go? Manager personal. After issuing notice to respondent number 1, who may nominate appropriate authority to represent CCL before respondent number 5. दोनों को सुन के ही ऑर्डर करना पड़ेगा ना, right?
He is represented before the deputy manager personally. He is already represented.
Let the notice go to respondent number 1. He will nominate himself. This writ petition is accordingly disposed of. Yes. हाँ बोलिए. The counsel for the petitioner has joined online. Yes.
Already representation to respondent number 5.
No, you have to file a fresh
Page number
representation.
22 is the representation submitted.
Fresh representation is required to be filed. You have to file a fresh petition, and then the respondent CCL will also be heard before passing the order. Afresh. You will get the order, right? The matter be disposed of by respondent number 5 within a period of 4 months from the date of the representation, from the date of the petition. Next.
Item 22, the LPS 4092 of 2023.
And in case there are any admissible dues, वो जो हम लोग order करते हैं, the same be remitted to the petitioner. Speed post से communication ये सब करनी चाहिए. Yes, petitioner.
Yes. Inquiry of Hakim Nitya Kala Mandir, Ranchi, and in the allegation of he was suspended, and the court has given to found guilty and sentenced him to.
Where is your order of dismissal? Where is your order of appointment? Where is your order of appointment?
At the time of dismissal, he was behind the bar.
Where is your appointment letter? Where is your order of dismissal? Because the impugned order says that you have not produced any document.
Yes, my lord, because the petitioner was behind the bar at the time of
At the time of
dismissal.
appointment also you were behind the
No,
bar.
no,
Where
no,
is
no.
your appointment letter?
Appointment letter is not, but from the from the conviction, it's clear that he was the employee of.
Conviction order will not decide anything. Where is your appointment letter?
Appointment
You have to
letter.
show your appointment letter, and you have also have to show your order of dismissal passed by the authorities.
My lord, may direct them to
No, we will
file
not
a
direct.
counter affidavit
No.
stating all these things.
Nothing. It
At
is
the
for
time,
you. No.
at the time of.
No. We will not ask them to do anything.
Lord, the problem is this, Lord, at the time of dismissal, he was behind the bar. He has not got the dismissal
Where
order.
is your appointment letter?
Appointment letter इतना पुराना नहीं मिल रहा है.
कहाँ बोले हैं कि नहीं मिल रहा?
नहीं मिल रहा है अभी.
ऐसा
और
नहीं
लेकिन
चलता
ये क्लियर हो रहा है कि हम वहाँ थे
Petitioner has
तब
to
तो
make out.
हमको जेल भेजा गया था उस केस में. अगर हम उसके एम्प्लॉय नहीं तो हमको जेल कैसे भेज दिए?
We do not know.
और आफ्टर
आपको रीजन ऑर्डर पास किया, आपने कोई डॉक्यूमेंट नहीं प्रोड्यूस किया.
जो डॉक्यूमेंट मेरे पास रहेगा हुजूर वही ना हम देंगे. तो वो डॉक्यूमेंट नहीं है तो इनको तो कम, हमको तो पिलर से पोस्ट और पोस्ट से पिलर कह रहे हैं. ये बोल रहे हैं पटना जाने, पटना बोल रहे हैं कि रांची जाने. हम कहाँ जाएं?
ऐसा नहीं बोल रहे ना.
ये तो बोल रहे हैं हम लगाए हुए आरटीआई से भी लिए हुए हैं. बोल रहे हैं कि आफ्टर 2000 bifurcation of the state, the liability and assets are with the Ranchi office. Kindly see the Annex 7 Lord.
आपको कोई रिकॉर्ड ही उपलब्ध नहीं है उनके पास.
काउंटर ये फाइल करके हमको बताए ना.
नहीं.
काउंटर तो हम पटना बोल रहे हैं कि आप रांची के एम्प्लॉय हैं और रांची बोल रहे हैं पटना के एम्प्लॉय. हम कहाँ हैं? हमको कुछ पता नहीं.
आपके पास कुछ नहीं.
मेरे पास अभी फिलहाल तो
और
नहीं
हम
है.
वहाँ से इंक्वायरी कराएं.
काउंटर फाइल करके हमको बताया था.
आपका एक्यूटल कब हुआ?
हमारे क्विटल हुआ 1998 में. उसके बाद हम यहाँ रिप्रेजेंटेशन दिए हैं कि हमको रिइंस्टेट करके हमारे बैक वेजेस वगैरह दिया जाए. उसके बाद यहाँ रीट फाइल किए. रीट में जो है ये बोले कि we will pass the order on that.
आपको डायरेक्शन था with all essential documents. You have not filed your representation with all essential documents.
These two documents is not with me.
You have no document. What document have you filed before this court? क्या है आपके पास? कुछ नहीं है.
ये तो हम शो कर रहे हैं ना कि
कुछ
हम
नहीं है.
employee थे तब ना हमको.
नहीं कहाँ से क्या
हमको
शो
जेल
करने
भेज
भी
दिया
do
गया
not
ऐसे ही.
क्या पता आपको डिसमिसल भी किया कि नहीं किया, किस ग्राउंड पे डिसमिसल किया. We do not know.
काउंटर में ये हमको
नहीं कुछ नहीं. आप हमको बताएं. उनके पास कोई रिकॉर्ड नहीं है. आप हमको बताएं. ऑर्डर में लिखा उनके पास कुछ नहीं है.
उनको 6 सप्ताह का समय दिया जाए. फिर क्लाइंट से हम कहते हैं कि खोद 6 सप्ताह.
WPS number 4092 of 2023. Counsel for the parties are present. The impugned order in the present case has been filed pursuant to order dated 22/2/2022 passed in WPS number 5758 of 2007, wherein the petitioner sought reinstatement and other benefits on account of his acquittal in the criminal case way back in the year 1998. This court had directed the petitioner to file a detailed representation along with all essential documents before respondent number 2 and 4, who were to pass a reasoned order. Upon perusal of the reasoned order as contained in Annex 5, it appears that the petitioner did not file any document in support of his appointment/discharge from service, and therefore no relief has been granted to the petitioner. In the writ records also no such document has been filed. Even the appointment letter has not been filed, much less order of discharge. Counsel for the petitioner, at this counsel for the petitioner prays for time till next Monday to file a supplementary
कितना
affidavit.
कम समय में नहीं हो पाएगा 6 वीक्स कम से कम दिया जाएगा खोजना बहुत पुराना डॉक्यूमेंट 6 वीक्स का टाइम दिया जाएगा
Time till 15th of May 2024 to file, time till 14th of May 2024 to file a supplementary affidavit annexing basic documents in connection with his service and his discharge from service on account of criminal case. Post this case on 15th of May in the supplementary cause list.
Item 23, the rupees 4221 of the Fund 23.
In this case, the manner in which the earned leave has been calculated, as per the information supplied to us, they have put a cap of 300 days, and thereafter they are not allowing that. I am relying upon one statement, but let me very fair to this one. Jharkhand Bihar Service Code, which is it says there will be, but my now contention is, before adding, if I earn the earned leave in a year, 14 days, 15 days, and I take leave for 5 days, after deducting that 5 days, if 10 days is added, the result would be different. What they are doing,
So
they add first.
There is a dispute regarding calculation. So far as capping is concerned, you do not dispute that.
Since
It's very, very clear.
Provision is very
which
much clear,
rule is there?
but similar provision has been there, is there in the Punjab Service Code, Punjab and Haryana Service Code, but the court has decided otherwise. So that is, I have annexed that order of the.
No, what do you want to argue?
I am just placing before you.
300 cap is there. As per which provisions?
227 of
227. Okay.
And then the resolution of the state government also.
That resolution enhances the date,
That's right.
day, number of days. It
But
is
the
240
manner
days.
in which it is calculated, you are disputing that. Who
I'm
will
just-
calculate
I'm-
this for you?
If
Who will calculate this for you?
It is the department. I'm just, since they have given me that, under RTI, I have taken the entire calculation sheet, they have provided me that sheet. I'm just wanted to show.
Respondent number 4 will calculate.
It is the.
Who will calculate?
I'm just. Respondent number 5, in the case of petitioner,
No, you see, we do not want any kind of confusion. Finance department is the best party to
Yes,
calculate.
department.
They will depute somebody to do the calculation, and no hearing. Please don't ask for any hearing. They will calculate it as per the
In
rules.
accordance with law.
I'm just
Although
trying to
they
place
are-
before your lordship what I am submitting before your lordship. I have made my contention in my rejoinder, bringing on record the calculation sheet given to us.
Okay.
Therefore, if
There is a calculation sheet.
yes, my lord, it is in the rejoinder, my lord. It starts from page 6 is the forwarding letter.
That's
and
right.
It starts from page.
Okay, they have given you the calculation
Yes.
sheet.
I'm
Fair enough.
just placing.
And where is your calculation?
my lord, my calculation I'm just showing from this only.
No. Where is
हम
your
ये
calculation?
क्या कर रहे हैं हम लोग कि मेरा जो earned leave I'm earning
ऐसा नहीं
earning
है।
for the year, they add first. If it goes beyond 300 days, they reduce it to.
ना तो हम चार्टर्ड अकाउंटेंट हैं ना हम अकाउंटेंट
Very
हैं।
simple,
2 + 2
very
4 नहीं समझ आता हमको।
I have stated about this, my lord, in paragraph number.
You see, they have given you the calculation.
Yes, my
You
lord.
make your own calculation and provide it to them.
The
They will
representation
compare
will
it
be for-
and it will be decided. That should be good.
Yes, madam.
Learned counsel for the parties are present. This writ petition has been filed for the following relief.
If I
The
may be
learned
permitted.
counsel for the petitioner has fairly submitted before this court that as per the Jharkhand Service Code and the circulars issued by the state government, there is a cap of 300 days in calculating total unutilized earned leave However, the counsel for the petitioner submits that the petitioner is still aggrieved as the calculation has not been properly made and proper deduction and inclusion has not been made at appropriate time and at appropriate place. He has submitted that he has received the calculation on the part of the department and has filed it in rejoinder to the counter affidavit, and he is trying to point out the errors in the same, and at the same time the petitioner has not filed his own calculation along with the rejoinder. This court is of the view that such accounting cannot be undertaken by this court, and it is primarily for the respondent number 4 to take into consideration the grievance of the petitioner, either himself or by deputing a person for that purpose as per the applicable norms of the department. Accordingly, this writ petition is disposed of, enabling the petitioner to file a representation before respondent number 4, annexing therewith a copy of the writ records and also a copy of the calculation which the petitioner proposes, which according to the petitioner should be the mode and manner of calculation. In support of such calculation, the petitioner may annex any applicable circular, etc., so that the grievance of the petitioner is taken to a logical end. The representation be filed within a period of 1 month from today. And the respondent number 4, either himself or may depute a person for the purpose, and who may pass a reasoned order in connection with the grievance of the petitioner within a period of 2 months from the date of the representation and communicate the same to the petitioner. The reasoned order shall also indicate the circulars, etc., on the basis of which the calculation reasoned order, that should be sufficient.
That would be sufficient.
That would be sufficient. If any amount is found admissible to the petitioner, appropriate steps be also taken so that the admissible amount is remitted to the petitioner within a period of 2 months from the date of the reasoned order.
Item 24, WPS 4283 of 2023.
Yes, petitioner.
Salary will also. Actually, our business are working as a computer operator, as a contract basis in Jharkhand Bihar Samiti also. And after serving such a long time, and salary is getting so less.
The circular issued by the state government is not applicable on you.
Yes. Yes.
Then how do you claim the benefit of that circular?
And the autonomous body, ma'am.
It is an autonomous body. The circulars are issued from time to time, and you are paid accordingly.
Basically, when petitioner was appointed, the board was following the instruction of finance department, and after the year 2012, they are not accepting, and they are enhancing of 1,000 rupees and 1,500 rupees per year.
That is an autonomous body. The circulars of the state government will not ipso facto applied on you. It is otherwise a contractual appointment. If you do not want, you could discontinue.
अच्छा इन्होंने एक लेटर एनेक्स 6-7 देखा जिसमें भेजा है कि अपना डिपार्टमेंट को लेटर भेजा है कि इसको क्या करना है बताने तो आया भी नहीं है ना कुछ हुआ है जो एनेक्स 7 है
कहाँ है बताइए
एनेक्स 7 पेज नंबर 91 है इसमें फाइनेंस डिपार्टमेंट का रेजोल्यूशन है जो सैलरी इन्हांस किया गया इसी के लाइट में पेज नंबर 93 पेज नंबर 93 इसमें कहा गया है कि लास्ट पारा पढ़ना अतः अनुरोध है कि वित्त विभाग के संकल्प संख्या 157 दिनांक 20/1/2012 के अनुरूप झारखंड राज्य कृषि विपणन परिषद के संलग्न कार्यालयों में कंप्यूटर ऑपरेटरों को 10,500 रुपया प्रतिमाह समय देने के भुगतान करने अनुमति प्रदान की कृपा की जाए, बट अभी तक वो आया ही नहीं।
डायरेक्टर बोल रहे आप ऑटोनोमस बॉडी है। बाजार समिति is an autonomous body, so they have to take their own call.
Yes, Lordship, but
You have not responded to this letter. ये कब का letter है?
Till date not responded.
2013.
तब finance department party रख सकते हैं, तो counter आ जाए उसमें।
Contract के live case होगा तभी ना counter. They have filed a counter affidavit. कौन file किया? Board has filed a counter.
Yes.
This for 3 and 4.
Okay. The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that petitioners have been working on contractual basis under the respondent number 3 and 4 and has submitted that the circulars issued by the state government with regard to enhancement of monthly payment for contractual data entry operator has not been made applicable to respondent number 3 and 4, and consequently the circular issued by the state government and consequently in spite of the circular issued by the state government, the petitioner has been deprived of appropriate payment, right? यही आपका grievance? The learned counsel appearing on behalf of the respondent number 3 and 4 has submitted that a counter affidavit has been filed in the present case mentioning that respondent number 3 and 4 that Jharkhand State Agriculture Marketing Board is an autonomous body and functioning by self-earned own resources, and at present the state government does not give any finance to the marketing board, and the payment is being made to the petitioners as per the remuneration enhanced by the board from time to time. He has also submitted that the circular issued by the state government cannot ipso facto apply to the respondent Jharkhand State Agriculture Marketing Board, and therefore the petitioner is not entitled for the relief as prayed for in the present case. To this, the counsel for the petitioner has submitted that on earlier occasion by letter dated 18/4/2013, the Jharkhand State Marketing Board had sought for instructions from the Finance Department. Page number 93 of the petition. But in spite of that, no instruction has been received. नहीं आया ना instruction. No instruction has been received, and therefore the stand of the Finance Department may be called for in the present case. Counsel for the respondents is directed to seek instructions and file instructions from respondent number 2 and file a counter affidavit in the present case. Let the counter affidavit be filed by 29th April. छोटा सा counter देना है. Post this case on 30th April in the supplementary cause list. You should give the sequence as to how it happened. Earlier तो शायद मानते थे, बाद में autonomous body declared. Next. These matters will come under the heading for admission. Supplementary में आएगा, लेकिन heading सबका admission.
Item 25, WPS 4349 of the 23.
Not before me.
Item 26, WPS 4598 of the 23.
Yes.
This petition has been filed for washing of letter dated.
Yes, respondent. Who is for the respondent? The learned counsel for the petitioner is present. Nobody appears on behalf of the respondents. The learned counsel for the petitioner submits that the petitioner has been working as PE specialist within bracket contract by virtue of contract which was to end on 31/12/2023, but the respondents have discontinued the petitioner by stating that the petitioner has attained the age of superannuation, that is 60 years, on 2/4/2023. The learned counsel submits that the employment is a contractual employment and therefore the scheduled date of retirement of government servant is not applicable and the petitioner is bound by the contract. And the parties are bound by the contract. The impugned order has been issued by respondent number? Respondent number 5. Okay. Let the counter affidavit be filed by respondent number 2 by the let the counter affidavit be filed by respondent number 2 as well as other respondents. नहीं ऐसे लिखे, the learned counsel for the respondents is directed to seek instructions from the respondents, including respondent number 2 and 5 and 2, 4 and 5, and file a counter affidavit in the present case by May 7th, post this case on 8th May in the supplementary cause list under the heading of admission. Are you continuing to work? The learned counsel for the petitioner has submitted that the petitioner has been discontinued. Yes, petitioner has been discontinued and the period of contract is over. Let us see what comes.
Item 27, WPS 4614 of 2023.
The petitioner had applied for postgraduate trained teacher competitive examination 2017. He was declared successful. After that, he was called for document verification. In
You file
document
your counter. Learned counsel for the parties are present. Let a counter affidavit be filed by respondent number 3 by 29.
Further, 1 week time may be
by 2nd May. कोई भी मार्क्स वार्क्स हो ना, मार्क्स से रिलेटेड कोई भी चीज़ हो, kindly put it on record. Post this case on 7th May 2024 in the supplementary process under the heading for definition.
Item 28 WPS 4712 of 2023.
Yes, petitioner.
This is for shifting the date of regularization. This is the third round of litigation. Earlier, twice petitioner has approached this one.
There is no vacant post on which you want yourself to be regularized.
They have already regularized me.
Because they have regularized you on another vacant post.
That is their criteria.
Different designation altogether.
On the post of driver, but in the different.
Driver, it's a different,
Yes,
different designation.
I was working as a driver, Your Lordship. But
No, you were working as road roller driver.
Yes, sir.
And they have regularized you on
As a jeep driver.
jeep driver.
Yes, sir.
Both are not one and the same.
Both are the drivers, Your Lordship. The
Driver.
only contention is.
Train ka driver, plane ka driver,
I'm
or
not-
roller ka driver,
I'm not on
or
that.
bus ka driver. They will form in the same.
Lordship, I'm not on that. I'm saying, Your Lordship, it is the admitted case of the respondent that since 1998, I'm continuously working.
Yes.
Lordship, kindly see the first order, that is Annexure 1, page 27. This is the first time I approached Your Lordship, this Honorable Court, and this order has been passed. Page 27. Wherein, Your Lordship, at page 29, it has been specifically mentioned that having considered the rival submission of the parties and having gone through the account material facts period, it appears that in view of Regulation Rule 2015, framed by the respondent, government petitioner can make a claim for regularization therein before the competent authority, subject to fulfillment of other conditions stipulated therein. One of the conditions contained that each other should have completed 10 years of works at daily wages. This is the criteria in 2015. Rating the claim also required to be satisfied in such circumstances. The petitioner is shown to have worked from 5/4/1984 till 31/7/1995 as per Annexure 11. Letter dated 6/3/2007 of the respondent authority himself. It would be appropriate that the petitioner case should be also be considered by the competent authority under the respondent department accordingly. The petitioner has been directed to approach Your Lordship to the respondent. Now, Your Lordship, Annexure 2, they have rejected my claim on, this is Your Lordship, 7th of June 2016, Your Lordship. Now, Your Lordship, kindly see page number 31 of the reason order. The last paragraph, Your Lordship. चौकीदार पर they are admitting कि 5/4/1984 से 31st March 1986. Thereafter 1/4/1986 से 31/7/1995. पथ वेलन चालक. Now, Your Lordship, the next line, Your Lordship, दिनांक 14/5/98 से श्री करण पुनः दैनिक वेतन पर पथ वेलन चालक के रूप में कार्य लिया जा रहा है. This statement they are giving in 2016, Your Lordship. That since 1998 I have been continuously working. Now, Your Lordship, in spite of that, they have rejected my claim. Now, I
They
have.
have not rejected your claim.
Yes, Your Lordship, kindly see. This is the rejection, Your Lordship.
That's right.
श्री करण द्वारा दिनांक इतना से इतना तक कोई कार्य नहीं किया गया है. फलस्वरूप इस अवधि को 9 पे लंबित अस्वीकृत किया जाता है साथ में.
So since 1998, you have continued.
Yes,
right?
sir. They
Prior
themselves.
to 1998, they have refused your
Yes,
claim.
Lordship. That I am relinquished, Your Lordship. I am praying that since 1998 I have completed 10 years in 2008, and as per 2015, Your Lordship, regulation
Where
policy.
is the order of regularization?
Now, Your Lordship, kindly see. I have again approached. I have challenged this order by way of Annexure 4, page 34. The same has been allowed, Your Lordship. And Your Lordship, operative portion is, Your Lordship, page 44.
Yes.
Para 8, Your Lordship.
This order has been set aside, 7/6/2016.
Lordship, there are several writ petitions.
Yes,
that have
where
been
is your challenge and where is your order?
heard. Yes, sir.
What was your case?
Yes, sir.
Which number?
Yes, sir. Just now. Lordship, the third case, Your Lordship, Daya Shankar Prasad. This is the petition. WPS 231 of 2017.
Okay.
Your Lordship, have got that?
All right.
Now, Lordship,
This has been set aside.
Lordship, all these cases were heard together, Your Lordship, and it has been mentioned in paragraph 8, Your Lordship. As a cumulative effect of the aforesaid observation rule guidelines 1, I hereby quash and set aside the ensuing orders rejecting the claim of the petitioners for regularization of their services, and the matter is remitted back to the respective respondent for taking fresh decision in view of the judgment passed by the Honorable Apex Court in the Narendra Kumar Tiwari, Your Lordship. And so far as the rest of the case is concerned, which respective respondent not taken a decision till date, they have to take a decision. Now, Your Lordship, I have represented through Annexure 5. Annexure 6, Your Lordship, again, what they have done, they have accepted in paragraph, Your Lordship, 1986 has accepted 1983. Now, Your Lordship, kindly see page 47.
Yes.
Yes, Your Lordship. The third paragraph, Your Lordship. Avkechen Abhyanta, Adhikshan Abhyanta, sorry. कार्य अंचल दुमका के ज्ञापन सचिन सच के द्वारा श्रीकरण के कारण स्थापना के तहत जापान के रूप में अस्थायी रूप से नियुक्त किया गया था, जिन्हें पुनः अपना द्वारा उन्हें रद्द कर दिया गया।
देखिए, अपना वर्ड छोड़ के मत करिए, हमको आदत नहीं।
हिंदी
हिंदी आपको क्या फॉरेन से आए हैं?
जाता है, बीच में छूट जाता है।
नहीं, ऐसे छूटने का नहीं
हम
है।
ट्राई करते हैं।
आप छोड़ के बहस कर सकते हैं, हम छोड़ के ऑर्डर नहीं कर सकते।
सॉरी।
राइट।
कार अंचल दुमका के ज्ञापन 649 दिनांक 28/7/95 के द्वारा श्री किरण को कार्यभारित स्थापना के तहत पथ बेलन चालक के रूप में अस्थायी रूप से नियुक्त किया गया, जिसे पुनः आदेश पत्रांक सचिन सच डेटेड 6/9/95 के द्वारा उसे रद्द कर दिया गया। फिर अधीक्षण अभियंता अंचल दुमका के ज्ञापन सचिन सच दिनांक 14/5/98 के आलोक में 14/5/98 से दैनिक वेतन भोगी के रूप में कार प्रमंडल दुमका के द्वारा कार्य किया जा रहा है। Lordship, they again accepted that since 14/5/1998 I am continuously working. This order is of 2019, Your Lordship. So twice I approached Your Lordship, twice they have accepted that since 1998 I am continuously working and I have been paid, Your Lordship. In spite of that, they have rejected my claim, Your Lordship. दावे को अस्वीकृत किया गया है, पुनः सम्यक दावा को अस्वीकृत किया जाता है। Now, Lordship, I have preferred a contempt application, and the order passed in the contempt petition is page 48.
Page 48.
Yeah. Annexure 7.
Yes.
Your Lordship has got it. Made it. Mrs. So-and-so Learned AG submits that in view of the order and direction of the court, Manohar Kumar, Superintending Engineer, Rural Department, present before this Honorable Court through video conference. From perusal of letter dated such and such, issued by the Superintending Engineer itself, it is apparent that the petitioner is working continuously since 14/5/98 till date. The facts have not been disputed by the Superintending Engineer, a Class 4 employee, working for the last more than 25 years till date, cannot be said to be working on unsanctioned post. if the post was not sanctioned and vacant, how the respondent has allowed them to continue from the year 1998 till date and making payment for the same. If the appointment was illegal, why his services have not been terminated till date? If the appointment is irregular, the state has to take steps for regularization in accordance with law. The judgment rendered in the case of Secretary State of Karnataka and others versus Uma Devi and others reported in 2006 for SEC 1 as well as in the
So
case
you
of
lost against it before the Supreme Court also.
against this order, Your Lordship, they have preferred an SLP and that has been lost, Your Lordship. And thereafter they have complied. But Your Lordship, what they have done, very surprisingly, from the date of joining they have regularized. And the fag end of service, Your Lordship, in the year 2022. I have worked from 1984 and continuously from 1998, Your Lordship. So at least my 10 years has been completed in the year 2008.
Yes, respondent.
And it is the finding of the court, Your Lordship.
Leadership, we have recognized the services of the petitioner subsequent to the decision passed by the cabinet, which is annexed in my annexure E.
Annexure E.
Annexure E to the counter affidavit. Effective portion is at page 14 of the counter affidavit.
Yes.
Para to Lordship. WPS number 231 of 2017 में दिनांक 21/8/2018 को पारित आदेश के अनुपालन
हाँ बताइए इतना लंबा ऑर्डर क्या पढ़ना
निश्चित लास्ट पैराग्राफ मुख्य अभियंता ग्रामीण कार्य विभाग झारखंड रांची द्वारा सूचित किया गया
हम लोग को जो कॉपी दिए हैं उधर तो पूरा ब्लैक है
द्वारा सूचित किया गया कि ग्रामीण कार्य विभाग के किसी भी कार्य प्रमंडल में पथ वेलन चालक का पद नियमित स्थापना में सृजित नहीं है। अधीक्षण अभियंता ग्रामीण कार्य विभाग कार्य अंचल दुमका द्वारा कार्य अंचल दुमका के विभिन्न कार्यालयों में जीप चालक का पद रिक्त प्रतिवेदित किया गया है। अतः श्री
You just tell us in the contempt order.
Yes,
it was clearly mentioned that how he has continued to work in an unsanctioned post. Rather, it cannot be said to be an unsanctioned post because he has continued. And उसके against में आप Supreme Court तक भी तो उसको modify नहीं कर पाए. Then while giving him the benefit of regularization, how do you confine him by saying that the post of road roller driver was not sanctioned and therefore he will be regularized against another post? Is it permissible under law? Right. So you
because if the petitioner has worked in for 25 years, the counter affidavit has come only that he has worked for his daily wage for the set post.
whatever it is, you have regularized him. So you have to regularize him from the day you have engaged him. एक पोस्ट से दूसरा पोस्ट शिफ्ट करके you cannot deprive him of the benefit of regularization and deprive him of the post-retiral benefits. When did you retire?
Yes.
This order dated 22/8/2022 is not under challenge before this court.
No, so that is order of regulation.
But order of regularization is with effect from which date? By
That they have not mentioned in that order, Your Lordship.
They have not mentioned.
Not mentioned, therefore I have mentioned. Page 52 kindly see.
You have annexed it in your repetition also.
It should be annexed C to that. In that order itself, we have stated leadership that second paragraph. उक्त पत्र के आलोक में श्री कर्ण ने दिनांक 7/9/2022 के पूर्वाह्न में जीप चालक के पद पर अपना योगदान कार्य प्रमंडल दुमका में समर्पित किया। उक्त तिथि से योगदान स्वीकृत किया जाता है। That is what the date itself.
Joining के बाद they have added this clause.
7/9/2022. In that order itself, it has been stated.
ये भी also it is also illegal.
7/9/2022.
You see, any order unless you specifically challenge, we will not interfere.
So that
This
That is
Writ
not
petition
mentioned.
has not been properly drafted. You amend it. We will give you the relief, but unless you challenge it, we will not.
As your Lordship, file an IO.
That no,
Since
there is
your
an
Lordship-
adverse order against you that is required to be challenged.
How will file?
The learned counsel for the parties are present. The learned counsel for the petitioner submits that although the petitioner has been regularized, but the effective date of regularization has not been properly given, due to which the petitioner has been deprived of post-retiral benefits. He has submitted that there has been several round of litigation, and in contempt case with the vacancy number 202 of 2019, it was specifically observed that the petitioner cannot be said to be working against unsanctioned post for a long time since 14/5/1998. He submits that the said order dated 1/10/21 passed in the contempt case was challenged before the Honorable Supreme Court, and the SLP has been dismissed.
That order has been.
And the order has been annexed along with the writ petition. In spite of that, the effective date of regularization has not been properly given. However, he submits that the order by which the effective date of regularization has been given to the petitioner is required to be challenged by filing amendment petition.
Since they have.
Needful be done by the petitioner by within a period of 1 week.
Since they have added that clause in the joining order.
That's right, whatever. Needful be done by the petitioner by कब तक कर लेंगे बताइए?
Within 10 days.
By 25th of April.
Yes, sir.
Post this case under the heading for orders on 29th.
Alright.
ठीक से ध्यान से देख के बनाइएगा. ठीक है? उस दिन का दिए हैं, कौन सा डेट का इफेक्टिव डेट है. आप इनको legible documents भी नहीं देते. No, he's not able to read.
Passover case item 11, WPL 1918 of 2023.
Yes, petitioner.
Leadership in this matter, Mr. Lalita, advocate in the law, he is informed that the client has taken NOC from me.
Mr. नाम बताएं अपना. Mr. Rahul Dev, advocate. On instructions of Mr. Lalit Yadav, advocate, has submitted that the petitioner has taken the file from him. Counsel for the respondents. Respondent number 1 and 2 are present. He submits that notice was issued to Mr. Amit Kumar was also present in the morning.
Amit Kumar Sinha.
Along with Mr. Amit Kumar Sinha advocate. He submits that notice was issued to respondent number 3, the union, and respondent number 3 is just a pro forma party. Therefore, the case may be taken up on the basis of materials on record. इसका record आता है lower court? The records from the learned court has already been received. considering the fact that in spite of taking no objection from the advocate on record, nobody else has entered appearance. This court appoints Mr. Rahul Dev as amicus in this case to assist this court in the disposal of the matter. आप record दे देंगे उनको? The counsel for the respondents is directed to provide a copy of the petition to Mr. Rahul Dev. The records received from the learned court will be made available to the parties for inspection and perusal post this case under the heading for final disposal on Thursday. फिर आपको नहीं अपॉइंट करेंगे, इतना स्लो स्पीड में चलने वाला वकील हमको नहीं जमता है। सारा रिकॉर्ड यहाँ पे देख लीजिए, कुछ है नहीं, फिर भी आपको बिना सुने डेट ऑफ बर्थ है और उसका बाद डॉक्यूमेंट्स में डिस्क्रिपेंसी है। थर्सडे छुट्टी नहीं है ना? टू बी टेकन अप एट 2:15 as first case, right?
Pastor case item 12, the LUPS 2710 of 2023.
Yes,
Petitioner was appointed on a 4th grade post as a peon in Retiral College, Retiral, which is a constituent college of Kolhan University, Chaibasa. Since 1986 till date, petitioner is discharging the duties of a 3rd grade post.
So merely because you are working, you are discharging the duties of 3rd grade post, you will be entitled for remuneration of 3rd grade post without any proper promotion order.
Your Lordship, provide an extra 16, Your Lordship. Provide an extra 17. There was a direction by the university to the college to conduct an examination and recommend the name of the qualified employees for promotion to the 3rd grade post.
There is
an extra 17, page 47, Your Lordship.
Page 47.
Yes, Your Lordship.
No examination was held.
Yes, Your Lordship. Examination was conducted. My name was recommended. Yes,
that is the recommendation.
Answer 18. Serial number 2.
What is your name?
Adhar Chandra.
Adhar Chandra. What about the others? Then what happened?
Then, Your Lordship, till date, no decision has been taken by the university, and again by the next 19, they again published the notification, Your Lordship, for promotion from 4th grade board to the LDC, Your Lordship. That is the next 19.
Page number?
Page 49.
Who is for Kolhan University? There is already a recommendation in their favor way back in the year 2012 itself, after conducting the examination, and you have come up with a fresh notice. And
the governor has made a new statute.
No, but recommendations which have already been made after conducting examination, can you sit over it like this?
Yes, my lord, I will file counter affidavit, it is already prepared today, but I do think that as per the statutes.
Maybe that this fact was not brought to the notice of the Honorable Governor, that there was already an examination conducted, recommendations made. It has not been scrapped, I suppose. Has it been scrapped?
No, it has not been scrapped.
If it has not been scrapped, how do you deprive them of the benefit of the examination which was conducted? And he claims to be working in class 3 post only.
On this specific point, why the promotion is not granted?
Yes.
I have
The learned
prepared
counsel
a
for
counter affidavit in which I have only said that his case for promotion under the statute shall be examined.
Leadership, if may have a look at page 46, which was written by the Adhyaksh Snatok Hindi Vibhag, Kolhan Vishwavidyalaya Chaibasa, the last line. अतः मैं recommended करता हूँ कि उन्हें officiating allowance प्रदान करने की कृपा करें. Even they are recommended my name for the officiating allowance.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that although the petitioner was appointed on class 4 post now falling under Kolhan University.
Yes, it is.
But he has been discharging his duties with respect to the responsibilities of class 3 post. And pursuant to a selection process for the purposes of promotion from class 4 to class 3, the petitioner had participated along with others, and the result was also declared by the Annexure 18 dated 12/4/2012. But neither the said selection process has been scrapped nor the promotion has been given to the petitioner.
Total posts were vacant at that time. That is
He-
also mentioned.
He submits that all the recommendations were made against vacant sanctioned post. The Learned Council further submits that on account of the fact that the petitioner has been discharging duties of grade 3, a letter dated 30/7/2022 was also issued to the Vice Chancellor Kolhan University for granting officiating allowance to the petitioner. Even the same has not been granted. The Learned Council further submits that now for the same post, a fresh selection process has commenced by letter dated 22/2/2023. क्या हुआ इस selection process में? It has been, people have participated. Mr. A.K. Singh, what happened to this selection process? Okay. The Learned Council for the respondent, Kolhan University, has submitted that the fresh recruitment is on account of the statute which has subsequently come in place. The counsel for the respondent, Kolhan University, is directed to seek instructions and file a counter affidavit in the present case as to under what circumstances the recommendation for promotion made in a letter dated 12/4/2012 to the bracket Annexure 18 was not given effect to. File kariye counter. Let the counter affidavit be filed by 29th April, post this case in the supplementary cause list on 30th April. The counter affidavit should also disclose as to what ultimately happened to the fresh selection process which commenced by order by Annexure 19 dated 22/2/2023, and whether the advertised post included the post which was for which the recommendation was made on 12/4/2012. ठीक है? Try करो. 29. 30th को रहेगा in supplementary cause list. You also find out, petitioner, what happened to the selection process. If the process is over, it is very difficult to grant you any relief. Right?
Masoro case item 20, WPS 3840 of 2023.
Yes, petitioner. नहीं हो सकता इसमें नॉट करो. What is the date of death? What is the date of death?
1984.
You are seeking compassionate appointment. 1984.
26 June 1984.
26/6/1984. Explain. Compassionate appointment. How many years have passed?
फाइल ही नहीं.
कोई बात नहीं, आपके पास फाइल नहीं होगा ना, ऐसा केस का फाइल नहीं रखने की जरूरत है.
उनको करना था रंजन कुमार सिंह ने.
नहीं, हम अभी डिस्कस करेंगे. आपको पहले ही बता दिए थे, इसमें हम आज डेट नहीं देंगे.
आज केवल कर लिया कल. ये
आज कोर्ट नहीं आए हैं वो.
कल के लिए
कोर्ट आए हैं कि नहीं आए हैं?
कि वो आए.
आपको बस बताइए कब तक, अभी से लेके शाम 6 बजे तक 8 बजे तक कब करेंगे ये केस? इस केस को हम एडजर्न नहीं कर सकते.
कल के लिए रख दिया.
नहीं.
कल कर.
No. If he has come to the court, ask him to take out some time to explain this court how compassionate appointment can be granted in connection with a person who has expired on 26/6/1984. And the petitioner was minor on that day. 14 साल की 12 साल का के थे petitioner उस समय. बुलाइए उनको. नहीं, आज एडजर्न नहीं होगा ये केस. इट्स अ फ्रिवलस केस ऑल टुगेदर.
तो सेकंड हाफ.
हाँ, सेकंड हाफ में बताइए कौन सा मुहूर्त निकालें आपके लिए. शुभ मुहूर्त.
सेकंड हाफ में
नहीं बताइए, शुभ मुहूर्त आप बता दीजिए. टाइम
3 बजे के आसपास.
3 बजे तो वो बहुत बिजी रहेंगे. 2:10 पे बैठते हैं फॉर दिस केस. 5 मिनट पहले.
सेकंड हाफ में कर ले.
5 मिनट पहले, जिसके पहले और कोर्ट बैठते हैं उसके 2-3 मिनट पहले बैठते हैं, जिससे कोई कंफ्यूजन नहीं रहे माइंड में. ठीक है.
सेकंड हाफ.
और नहीं भी आएंगे तो केस डिसाइड करेंगे.
Item 29, WPS 4922 of 2023.
Yes, petitioner.
Relates to the payment of retired dues on the basis of 7,000 recommendations. One of the petitioner was appointed on compassionate ground on 3rd December.
It is now pending before the registrar Vinod Bihari Mehta. You know the need for?
Yes, it is. Till if no decision has been taken.
Decision has to be taken.
Yes, it is. There are 2 representations. One is pending before BBMKU and one is before Vinova Bhari.
But the representation has to
be decided by the
Collegial.
They will.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner has attained the age of superannuation on 31/7/2021, but the pension and other service-related benefits have not been paid to the petitioner to the extent prayer has been made in this writ petition. The learned counsel appearing on behalf of Vinova Bhave University has submitted that a counter affidavit has been filed stating that the matter has to be decided by the respondent Vinod Bihari Mehto, Kolyanchal University, Dhanbad. Who is for Vinod Bihari Mehto? You are. The learned counsel appearing on behalf of the said university has submitted that appropriate order may be passed so that the decision in connection with the grievance of the petitioner is taken. He has submitted that once a decision is taken, the matter has to be referred to the state government for approval, and thereafter appropriate payment can be released in favor of the petitioner. After hearing the learned counsel for the party and considering the fact that as per the records of this case, appropriate decision has to be taken by Registrar Vinod Bihari Mehto, Kolyanchal University, Dhanbad, for which a letter dated 24/1/2024 has been issued by the respondent Vinova Bhave University to the aforesaid registrar. This court is of the view that no useful purpose will be served by keeping the present writ petition pending. An appropriate direction is required to be issued to the registrar of Vinod Bihari Mehto, Kolyanchal University. This writ petition is accordingly disposed of, enabling the petitioner to approach the respondent number 3 by filing a detailed representation with regard to his service benefits / post-retirement benefits, along with a copy of the writ records. Upon filing of such representation, the respondent number 3 shall verify the facts in connection with the petitioner by seeking necessary information from respondent number 5 and pass a recent order after granting an opportunity of hearing to the petitioner within a period of 2 months from the date of the presentation. The recent order be communicated to the petitioner through speed post, and if the claim and be also communicated, and appropriate communication be also made with the state government for seeking necessary approval, and thereafter the respondent number 1 and upon receipt of communication from the respondent number 3 with regard to the claim of the petitioner, the respondent number 1 shall take appropriate steps so that the grievance of the petitioner is ultimately redressed in accordance with law within a period of 4 months from the date of receipt of such communication. That's it. The state petition is accordingly disposed of.
Item 30, WPS 5062 of 2023.
Pass over. What is the nature of relief?
Petitioner placed for payment of retirement benefit.
Who will? This is cooperative bank.
Yes, Lordship, Jharkhand State Cooperative.
You file a counter affidavit in this case.
It has filed counter, Your Lordship.
Your cooperative bank should file a counter affidavit.
He is the clearing manager.
Yes, Lordship, I have filed.
Cooperative bank has filed a counter affidavit. What is your stand?
Lordship, in this matter, Lordship, there was a defalcation of rupees 12 lakh in total by the petitioner, Lordship, in the year 2009. Lordship, thereafter, FIR was instituted and criminal proceeding has been conducted, Lordship, and he was subsequently exonerated of the charges in the year 2023 in the month of September, Lordship, and since the petitioner has superannuated in the year 2012, the departmental proceeding was not concluded, Lordship, against the petitioner, and it is still pending, and a certificate case was also instituted against the petitioner for defalcation of rupees 12 lakh, that is also pending, Lordship.
Where have you mentioned all this?
Yes, Lordship, it has been mentioned. It is mentioned in paragraph.
Without taking the departmental proceeding to a logical end, you have filed a certificate case for recovery.
Yes, Lordship, it has been done, Lordship, in the year 2012. And the charge sheet was issued to the petitioner, Lordship. That is a charge sheet dated 15/6/2012.
When was your bank constituted? You have any idea?
Yes, Lordship.
When was your bank constituted?
Constituted, Lordship, this bank was constituted, Lordship, amalgamated in the year 2017 as Jharkhand State Cooperative Bank, Lordship. Earlier it was
It was constituted on 1/9/2012.
Yes, Lordship.
So you want to pay him the retirement benefits?
Lordship, the departmental proceeding may be decided, Lordship. The departmental proceeding.
Is it going on?
Yes, Lordship. It is still pending, Lordship.
Pending?
Yes, Lordship. We will take any decision, Lordship, in this regard.
Take a decision in the departmental proceeding.
Yes, Lordship.
So, petitioner is participating in the departmental proceeding?
Lordship, for that I have to seek instruction, rather. Because this case has been filed, Lordship, very recently after he has been exonerated from the charges in the criminal proceeding, Lordship. He has annexed that.
Where have you mentioned about the departmental proceeding? things I want to know. Where is the order of
At
certificate proceeding? At
Paragraph
paragraph.
12 of my counter affidavit.
Page number?
Page number 6. Charge sheet was issued, and thereafter.
No, para 12. Respondent number 2, counter affidavit.
No, respondent number 3.
Okay, Papatrika. Para number 12, right? Okay.
Paragraph 12, then Lordship, at paragraph 14, it has been stated that certificate case has also been instituted against the petitioner.
Departmental proceeding could logically come to an end upon superannuation. How?
Lordship, that's what I'm saying, it is still pending, Lordship. So we can take any decision in this regard.
How have you made this statement? Yes? How have you made this statement? Is this the law of the land?
No, Lordship.
Then you don't vet the counter affidavit. Who has filed? Who has drafted this counter affidavit? You file supplementary affidavit. We don't. You just take care of this paragraph.
Yes, Lordship.
नहीं देखते हैं फाइल करने के पहले.
That is an inadvertent mistake, Lordship. Departmental proceeding can be proceeded even after the superannuation.
The learned counsel for the parties are present. The learned counsel for the respondents has submitted that a departmental proceeding was initiated against the petitioner and charge sheet was issued by letter number 126 dated 15/6/2012 and also subsequently by letter number 301 dated 19/11/2013 and the petitioner superannuated from service on 30/6/2012. The learned counsel for the petition respondents prays for time with specific reference to the statements made in paragraph number 13 of the counter affidavit filed on behalf of respondent number 3. Post this case on next Tuesday. Supplementary list.
Item 31, WPS 5439 of 2023.
Yes.
Yes, Lordship. It has come for the first time. Congress has been filing this
किस
case.
तरह का आप ये पोस्टिंग किए हैं? 3 दिन एक स्कूल में, 2 दिन दूसरा स्कूल में. What is this? What
Case
kind
is,
of?
Lordship. So Congress is required in this case. I can't.
No, this counter should come from this director. Respondent number 3 should file the counter affidavit.
Right.
Right? Counsel for the petitioner has joined online. The learned counsel for the respondents is present.
One is private respondent, Lordship.
Okay.
7.
Respondent number?
7 is private respondent.
You are for respondent number 7?
Not for 7.
Okay.
Apart from
Respondent
7,
number 1 to
to
6 is present. Upon perusal of the impugned order as contained in Annexure 17 is the impugned order? As contained in Annexure 17, it appears that
That's 17 and 17.
the petitioner has been directed to discharge her duties. Female है? Female है? Discharge her duties in 2 schools, and the days for each school has been fixed. Counsel for the respondents is directed to seek instructions from respondent number 3, who in turn shall seek necessary information from the other respondents and file a counter affidavit in the present case. Let the counter affidavit be filed by by 30th of April 2024. Post this case on 1st of May in the supplementary cause list. ऐसा तो नहीं होना चाहिए ना, थोड़ा सा डिफिकल्ट लग रहा है, कुछ गड़बड़ है. हाँ, something, some ego hustle is there, it appears.
Mention case item 3, WPS 73 of 2023.
May it please. But if in my own words, I'll explain the controversy with reference to a few facts before I come to the. But in 2014, the respondent here, that is the private respondent, is working as a sub-editor with the petitioner. In 2014, he applies for a 14 days leave, overstays the leave without any information being given to the management. But the management, after 1 month of that period having elapsed and receiving no information whatsoever from the respondent here, they issue him a show cause notice that you have not come back, why your services should not be terminated. It's a plain and simple show cause notice. Against that show cause notice, instead of replying to that show cause notice, he files a claim before tries to raise an industrial dispute under 2A before the authorities, and the authorities then subsequently refer the matter in 2017. The references, it's, I'll just give the number of the reference.
Under 2A?
On 2A, 2 capital A.
How is it maintained?
That is what I'm trying to say, 2A, because there was no termination order which was passed. He was claiming that in my place somebody else has been appointed, so it's, for all intents and purposes, it's a termination. That was his case, the matter came up before the Labour Court. In 2017, this matter
reference was made?
Reference was
made.
Where
is the terms of reference?
It's section 1, I'll just point out, page 28, whether the termination of in service Mr. Shri Imran Ali by Messrs. So-and-so is justified. If not, what relief he is entitled to. So this reference, it continues. Both the side lead evidence, Then, after 5 years, in 2022, the management witness appears. That is DW12. That's right. He makes a categorical statement that till date we have never passed any termination order. Then the petitioner before the Labour Court gets wiser. He moves a specific application to the management, not to the court, that I am ready to join back, but lays down a whole list of conditions that I will join back only if the conditions are fulfilled. The management in its wisdom, replies there that if you want to join, you join. We will not take you on a conditional basis. All these conditions are unacceptable to us. The matter does not come before the Labour Court on this aspect, but the fact of the matter is we've attached those documents in Annexure 4 to 7, where there's a communication going on during the pendency of the dispute before the Labour Court under 2A. The matter comes up for final arguments. At that point of time, when he realizes this fact, that the management is not going to budge, they are not going to take me back into service on my conditions. Because the stand of the management is either take an order or come simpliciter join, all the other conditions can be worked out subsequently. But then, once this happens in 2022, something very interesting happens, Murad. Since 2014 till 2022, something new comes up. He says that the reason for my termination was that I was asking for a revision of pay scales as per the Majeethia Wage Board, which has been constituted under Section 9 of the Working Journalist Act. And of course notified under Section 12, matter travels to the Supreme Court. The Supreme Court upholds that, the Majeethia Wage Board recommendations. He says, because I was raising this demand, that is the reason why it has been terminated. And now, the strangest part comes. This application is moved before the authorities, and on two grounds he moves it. That one, in the earlier reference of 2017, my name has been misspelled. One, and number two, the Majeethia Wage Board recommendations, whether I am entitled to them or not, should also be made a part of the reference. The government, that is the appropriate authority, without even calling upon the management, amends the earlier, makes an amendment and adds this. They keep the initial reference as the same, the first two lines, whether his termination has been legal or illegal, what relief he is claimed to, and adds thereto, by way of an amended reference, that is the impugned reference before this court, to say whether the Majeethia Wage Board recommendation makes him entitled to receive a particular scale of wages. I go to the extent of saying the scale of wages. We come to this Honorable Court challenging this recommendation. Once notice is issued, the state files a very simple reply. It says that the Majeethia Wage Board recommendation, which had been made earlier, is a part of the same reference. It's a continuation of the same reference. So that is why we have the power to amend it. Respondent number 4 herein, my lord, that is the aggrieved party, that is Imran Ali, the workman, the sub-editor. My lord, he files a counter to say that the government, even if it is not made under the General Clauses Act, if the government has the power to make a notification, it has the power to amend it also. So, my lord, my arguments, this is the narration of facts, and my lord, one interesting factor, this gentleman joins the management.
So, you are challenging the initial reference also?
No, my lord, we are challenging the amendment, because the initial reference has actually culminated into the evidence being led, one, and the matter having to come at the final stage of arguments. But once he realizes this fact that once there is no termination order, in all probability, the court cannot hold the termination to be bad, because in the absence of that order. So seeing the futility of that exercise, he says, how can I arm twist the management to get something out here? And Lord, we have specifically said, I don't know how much value we can put to that. During the time when he was out, from 2014, when according to us he abandoned his post, Lord, he becomes a law graduate. That is where I would say that things started moving in a particular direction. And in 2022, after the statement made by the management witness, he realized one thing, that in the absence of a termination order, the initial reference, but by that time it has reached the stage. Now, by amending this, on two grounds, my primary challenge would be, once he is talking about a revision of wages, because according to me, even for the sake of argument, if the initial reference is allowed in favor of respondent number 4, whether his termination was good or bad, if it is decided in his favor that it was his services were illegally terminated, then the consequential relief would be that he would be granted back wages from the last drawn salary that he was getting. Once he travels beyond that scope of revision of wages, then, one, the state government, in their written statement at one point of time says that we have invoked our powers under 2K. The moment they say that, it's an individual dispute. It cannot be taken up under 2K. This is one. Number two, the act and conduct of respondent number 4 clearly goes to show that this dispute never existed, because since 2010 till 2022.
So far as the wages are concerned, it is something which is going to affect everybody.
That
it has
is
to be an industrial dispute.
That is precisely. That is why I say an individual dispute. If it has to come within the domain of an industrial dispute, then the Supreme Court says, in the latest judgment now, that if it is going to affect 100 people, and we are employing 100 people, then the Labour Court will not have the jurisdiction to decide it. It will have to go under Schedule 3 to the tribunal. That is a categoric stand, and that is what the Act itself says. The statute itself says so, but it has been elaborated in the recent judgment by the Honorable Supreme Court in 2023. I'll just point out, this is this is Civil Appeal number 8801 of 2012 and decided on the 17th of August in 2023. Can I get, please hand over the copy, please?
The dispute as to what could be, this is not a dispute relating to consequential relief.
That is
it is a dispute relating to a different contour altogether.
Total. He has taken a somersault, and that is why I say that the procedure of a conciliation, at least I have the right to be heard. If it is to be, paragraph 11 I would be referring to, after the reproduction.
Have you stated that, is it an admitted fact that no notice was issued to you at this stage?
Absolutely, my lord. None of them.
Where is the state counsel? Are you appearing for the state?
Yes, madam. I am appearing for the state, madam.
Yes, what is your stand with respect to?
I will be permitted to state, madam. The respondent number 4 has approached before the government, madam, of the dispute for against the termination of services.
Okay.
As per, my lord, in the notification issued in the year 2017, madam, the reference was made. They are seeing that the subsequent reference of, my lord, that is in question, my lord, is, my lord, bad. My lord, we have stated regarding, my lord, that the workman has paid for the wages, emolument and other facilities, my lord. We have given a categoric statement in para 22-23 of the counter, madam. We are permitted to, my lord, state.
You see, whenever any order of termination is set aside, the consequential relief is certainly as per the evidence is led. But when he is seeking that a further relief, that he is entitled to regular dues, salary facilities, other emoluments under Majetia Wage Board award, then under such circumstances he is seeking his revision of the last pay drawn also.
Absolutely.
Yes.
How is it possible?
Lord, as the respondent.
And this kind of dispute is essentially not a part of an individual dispute. If this issue is decided in a case of one workman, suppose it goes against that, then there will be a judicial pronouncement in connection with affecting all the other workmen. So this is something which has to be raised by as an industrial dispute, not as an individual dispute under section 2A. And no notice was issued to them.
Regarding notice, Lord, there is silent number, but the.
So you will do whatever you want to.
Lord, Annexure 8, the respondent work has approached, Lord. Annexure share it with
So he will approach and he will keep on amending the terms of reference, that too after everybody has laid evidence.
only with regard to redressal of the dispute between the management and the workmen.
There can be n number of disputes between the workmen and the management. So you'll keep on amending the terms of reference. How do you amend
Resolve
it?
the dispute under section 10(1) as stated, the amendment was
This
made.
is not a reference under section 10.
Also 2K is written.
2K is written.
How is it 2K?
Only is permitted to state certain paragraphs.
The private respondent is seeking time, we do not know. Where is the private? Somebody was representing private respondent in
But
the
a
morning.
request was made on ground of a medical
Yes.
condition in the morning.
So when do they want the matter? Now he's absent. Who was there in the morning? Where is he? Where is he? The proceedings are on.
Well, the proceedings are on. We have pressed.
What is the next day?
What's the next date in the proceedings before the Labour Court? But I just informed before the Labour Court.
Otherwise, the evidences are complete.
Evidence is complete. It is listed for final arguments. I've attached all the documents, my lord, the Zimini orders also. And for 5 years, he kept on taking dates, my lord, on one pretext or the other. I'll just give the date. 29th of April, my lord.
We'll decide it prior to that.
My lord, my difficulty would be I would be available on the 13th, my lord.
13th of May.
My lord, the difficulty is, yes, I can join through VC, but I, for one, am not too fond of sitting down in my office and addressing the court, my lord. I'll be very honest with the court. I feel it is disrespectful.
You come from Kolkata?
My lord, I come from Punjab, my lord, Chandigarh. My lord, till the next date of hearing, I can assure this court, I can give an undertaking before this court that from our side there will not be any adjournment. At least the Labour Court may be directed to adjourn the matter beyond the 13th without taking any proceedings on the 29th. That's the only thing which I am praying for at this stage.
Where is Mr. Sadab bin Haq?
But we did argue a matter before.
Okay. Where is your IA? We'll stay the proceeding.
But the entire order sheet is annexed in the IA, my lord. The last date is shown, my lord, 17/7/2023 with respect to the reference score of 17.
No, but they are on instructions. He's saying that 29th is the next day. Where is that
But,
IA?
my lord, the last date is, my lord, 17/7/2023, my lord. Thereafter, what has happened, my lord, there is nothing.
We
But
trust
this is IA
if you
number.
make a statement, we trust you. Otherwise, also such kind of proceeding, how is it going? How it can go on like this? IA number?
We got 6668 of 2023.
Heard the learned counsel for the parties. Kindly give your appearances.
Not I.
WPL number 73 of 23 with IA number 6668 of 2023. The learned senior counsel appearing on behalf of the petitioner has submitted that a reference was made under section 2 capital A of Industrial Disputes Act by notification dated 13/2/2017 within bracket page 28. The reference was in connection with termination of service of the private respondent. And as to whether the termination was justified, and if not, what relief he was entitled to. The learned counsel has submitted that though no order of termination was ever issued to the private respondent. However, the matter having been, this is a reference under section 2A.
2A.
The learned counsel submits that the reference having been made under section 2 capital A of Industrial Disputes Act, the petitioner was participating in the proceedings and the parties were participating in the proceedings and the evidence has already been completed and matter is at the stage of argument.
Fine.
However, in the midst of the proceedings, the terms of reference was amended.
On an undated letter, that is annexure A8 at page 68.
I'm just
That's
referring
right.
it.
Maybe.
The terms of reference was amended and an additional term, namely whether the private party in the present case is entitled to get his regular due salary, facilities and other emoluments under the Majetia Wage Board Award. And number 3, whether he is entitled for any other compensation too. The learned counsel submits that the terms of reference has been amended without issuing any notice to the petitioner and there has been no conciliation in the matter of additional relief sought for through the amendment. The learned counsel has further submitted that the amended reference has changed the contours of the dispute between the parties. He submits that the relief which could be entitled, which the private party could be entitled to is already a part of initial reference dated 13/2/2017 and the reference to the wages under Majetia Wage Board Award cannot form a part of individual dispute as the same has the impact on all other employees of the petitioner. The learned counsel has submitted that the amended reference is under challenge in the present proceedings and the further proceedings before the learned court be stayed, in which the next date is on 29th of April 2024. The learned counsel has also relied upon a judgment passed by the Honorable Supreme Court, passed in Civil Appeal number 8801 of 2012, decided on 17th of August 2023.
Paragraph 11.
Paragraph number
11.
11.
Which says that if it is more than 100 workmen, then it has to go before the tribunal.
Okay. To submit that in an organization where there are more than 100 workmen, then the industrial tribunal will have the exclusive jurisdiction to try such a dispute. So it said the petitioner has more than 100 workmen and therefore otherwise also the amended reference was not maintained. When do you want?
Next Monday, on 22nd.
The learned counsel appearing on behalf of the private respondent has submitted that the arguing counsel is not available today on account of personal grounds, and he submits that he is ready to argue the case on next Monday. The learned counsel appearing on behalf of the respondent state has submitted that a counter affidavit has been filed on behalf of the state by referring to section 2 within bracket K of the Industrial Disputes Act, right? However, it is not in dispute that prior to amending the terms of reference, no notice was ever issued to the petitioner, correct?
Regarding notice not decided.
They must have said.
We have said so.
Now they have appeared.
Yes, they have appeared. They have no option but to appear. Considering the aforesaid facts and circumstances, at this counsel for the petitioner has submitted that the matter may be posted on 13th
of May.
13th of May. I am not sure if we will be able to take up on 13th. So difficult to say. It's the last working week. But anyways, we'll post it on 13th.
Wait, please.
Okay. Considering the aforesaid facts and circumstances and the nature of dispute involved in the present case, which relates to jurisdiction of the government to amend the terms of reference in the manner it has been done in the present case, this court is of the considered view that further proceedings before the learned court is required to be stayed. Accordingly, further proceedings in
Reference number 4 of 2017.
In reference case number 4 of 2017, pending before the learned Labour Court. Labour Court Ranchi is stayed till the next date of hearing.
Great.
Post this case on 13th of May 2024. It is under final disposal.
It is today. It is for the
yes, to be taken up at 2:15.
Great.
To be taken up at 2:15. Parties to file their short synopsis, list of dates, and the judgments which they seek to rely upon, and also the provision of law, extract of the provision of law, which they rely upon, latest by 9th of May.
Great.
Communicate.
Item 32, WPS 7081 of 2023.
Yes, petitioner.
Petitioner pays for regulation of his service, and the case of petitioner is also covered with the judgment of this honorable court in respect to similarly situated employee of the department. And this is para 15 5. Number 36.
Any order has been passed in your connection? Any counter affidavit filed?
Counter not pending.
Counsel for the parties are present. The counsel for the respondents is directed to seek instruction and file it. इनका consider किया है case नहीं किया है?
Does not appear from the petition.
तो consider कर लीजिए counter लेके क्या करना? कौन consider करेगा पता है?
Join किया on behalf में उसके बाद subsequently his service has been.
Just a moment. The learned counsel for the respondents is directed to seek instruction and file a counter affidavit in the present case by 14th of May. 14th of May, rejoinder if any by 12th of June, post on 18th of June under the heading of admission. Next.
Item 33, WPS 7182 of 2023.
This petitioner.
Petitioner association is here for grant of ACP to its members on the date of eligibility, that is date 14th.
Where is the resolution to move this court?
Yes.
Where is the resolution to move this court? And where is the statement that none of the persons have individually moved this court?
Yes, that I have mentioned in supplementary affidavit. Para 6 all the names as my ladyship's order in a writ petition, my lord, all the names are furnished office bearers of the association.
And that nobody has moved individually?
No common paragraph is there. We have not moved before this honorable court for the same cause of action earlier.
You have given the list of
Yes, office bearers.
office bearers and the list of members.
Members is entire police department. They are around 40,000.
आपका कोई indefinite number तो नहीं हो सकता ना?
And from the rank of ASI to the rank of inspector, जितने भी लोग हैं सारे मेरे members हैं.
So do you want to say? Do you want to take the responsibility of saying that nobody else has moved this court?
From this petitioner association which is before this one.
आप समझ नहीं रहे. एसोसिएशन की तरफ से रिट फाइल हो जाता है, इंडिविजुअल आदमी भी रिट फाइल करता है, उसके बाद कॉन्फ्लिक्टिंग ऑर्डर्स हो जाता है. उसको जब मन होता है अपना एसोसिएशन की तरफ से परस्यू करता है, जब मन होता है इंडिविजुअली परस्यू करता है. बिना आपके लिस्ट के, अगर लिस्ट मांगेंगे ना तो सिटीजन ऑफ इंडिया का भी लिस्ट मिल जाएगा.
Individual question है कि whether the order passed in this case is not binding upon the
अगर मान लीजिए हम इसको डिसमिस कर
member of the
दें
association.
तो क्या होगा? इस तरह से नहीं हो सकता मिस्टर. कुछ नहीं चलेगा. ये सब इंडिविजुअल ग्रीवेंसेस है. 50-50 आदमी मिलकर भी फाइल कर दीजिए. इस तरह से एसोसिएशन से केस
नहीं, सिमिलर केस ऑलरेडी डिसाइडेड है.
आपने क्या, हम बोल रहे हैं हमको आई डोंट एग्री, इसको चैलेंज कर दीजिए आप एलपीए में.
I will give the list of my lord.
And also the statement that none of them had moved this court for the relief as prayed for. दोनों चाहिए हमको.
And they will abide by the order passed by this honorable court.
This we will not permit.
As a binding procedure.
इसीलिए एआई का जरूरत है.
इसमें एक चीज है, ये जो बना है एसोसिएशन, ये हमारे मेंबर्स के ही.
बहुत अच्छी बात है, आप बहुत अच्छी बात है.
और ये रजिस्टर्ड और रिकॉग्नाइज्ड है पुलिस डिपार्टमेंट से.
आप सारी बातें बिल्कुल सही है, लेकिन हाउ कैन यू टेक a responsibility to making a statement that none of the members have moved this court?
Office bearers have not.
ऑफिस बियरर से क्या मतलब है हम लोगों को?
Because वही लोग एसोसिएशन को रिप्रेजेंट कर सकते हैं, मेंबर्स नहीं कर सकते हैं. वो इंडिविजुअल कॉज ऑफ एक्शन के लिए आएंगे, वो सही जाना चाहते हैं.
अगर कोई इंडिविजुअली इसी केस के लिए ऐसा ही रिट पिटीशन फाइल करते हैं, ठीक है, और किसी भी कारण से वो डिसमिस हो जाए, तो he will take advantage of this writ petition.
नहीं, I am saying कि ये writ petition तो already decided है. ये पहले से ऑर्डर इसी हाई कोर्ट का डिसाइडेड है, उसी को फॉलो करना है बस इसमें. वो ऑर्डर कंप्लाई नहीं कर रहे हैं.
तब कंटेम्प्ट कर लीजिए ना.
कंटेम्प्ट my lord 2001 का ऑर्डर that has attained finality in झारखंड पुलिस एसोसिएशन वायरलेस केस. ऑनरेबल कोर्ट हेल्ड की डिले जो होता है.
आपको मालूम नहीं है, एक हमने अलग से ऑर्डर किया इसीलिए.
हाँ, उसी पे हम लोग सप्लीमेंट्री डिफेक्ट.
हाँ, इसीलिए वो जो ऑर्डर है ना उसका कंप्लायंस करिए या उसको सेट असाइड करेंगे.
वो उसी के कंप्लायंस में ऑफिस बेयरर.
उसमें क्या ऑर्डर है? कहाँ है वो ऑर्डर की कॉपी?
वो डिफेक्ट लगा था.
ऑर्डर की कॉपी कहाँ है जिसके तहत ये फाइल हुआ? उसमें दोनों चीजें हैं.
WPS 523219 में ये ऑर्डर आया था माय लेडीशिप का.
5232.
हाँ, 2019. ऑर्डर 30/11/2022. इसी के कंप्लायंस में
ये जब ये ऐसी नजर में आती है ना, टीचर्स के एसोसिएशन बना के केस फाइल करने.
ये बना एसोसिएशन ये 100 साल पुराना इतिहास.
आई नो, इतिहास बहुत पुराना है, लेकिन
1920 का ये एसोसिएशन.
लेकिन लॉ भी उतना ही पुराना है.
नहीं, ठीक है.
आप हमको सिर्फ इतना बताइए, अगर कोई इंडिविजुअल आदमी अपना केस फाइल करे और उसका केस डिसमिस हो जाए, तो उसको इस ऑर्डर का एडवांटेज मिलेगा कि नहीं मिलेगा?
इंडिविजुअल बहुत सारी चीजें, जैसे इसमें ये लोग 3 रीजन निकाल दिए कि वो पहले अटेम्प्ट में अगर फेल कर जाएगा, तो वो सब इंडिविजुअल का अलग अलग चीज होता है कि वो पहले अटेम्प्ट में पास किया है कि फेल किया. अगर फेल किया तो उसका केस
एवरी एसीपी वगैरह का ग्रीवेंस इज एब्सोल्युटली इंडिविजुअल ग्रीवेंसेस. इसको इस तरह से नहीं ले सकते.
इसमें 3 रिट पिटीशन ऑलरेडी इधर पेंडिंग है ऑनरेबल हाई कोर्ट में. उसमें सब कुछ
सब में वही ऑर्डर करेंगे अगर मेरे पास आएगा.
ये 2019 का है और
2019 में तो मेरा ऑर्डर नहीं था ना। ऐसा हम लोगों ने बहुत देखा हुआ, आपको पता नहीं। लीकर एसोसिएशन का केस फाइल हुआ, इसीलिए हमको मालूम है। लीकर एसोसिएशन का केस फाइल हुआ, उसके बाद उसका केस डिसमिस हो गया। फिर इंडिविजुअल आदमी आ गया, बोला कि हमको क्या लेना देना है एसोसिएशन से।
we have not authorized to the
We never authorized the association to file a case. उसके बाद इंडिविजुअल केस शुरू हो गया। ये सब हमारे प्रैक्टिस के समय की बात है, इसीलिए वो ऑर्डर किए। ये सब करके जज बने। इसीलिए वो सब मत कहानी हमको सुनाइए, ये सब मत सुनाइए। ओके, ऑर्डर किए हैं, उसका कंप्लाइंस करिए। नहीं कर सकते हैं तो हम इस केस को डिसमिस करेंगे। Whether any writ petition is filed on behalf of Sangh Association, it should be incumbent upon to clearly disclose the name of their members along with their parentage and address whom the Sangh Association is representing, so that multiplicity of writ petition for the same cause of action, one through Sangh and another in individual capacity, is avoided. इस ऑर्डर का कंप्लाइंस करें, नहीं तो अपना इंडिविजुअल केस फाइल करें। WPS नंबर नहीं चलेगा, बहुत मुश्किल है, आप ऐसा एफिडेविट नहीं फाइल कर पाएंगे। WPS नंबर 7182 of 2023, counsel for the parties are present. The supplementary affidavit filed in the present case is not in terms of order dated 30/11/2022, passed in WPS number 5239 of 2019. Counsel for the petitioner seeks time to prays for time to seek instruction. Post this case on Wednesday रख देते, Thursday रख देते। कितना लंबा टाइम चाहिए इंस्ट्रक्शन लेने के लिए? ऑन पर्सनल डिफिकल्टी है तो 2 हफ्ता तक दिखने नहीं चाहिए कोर्ट में। On 30th April 2024 in supplementary cause list under the heading for orders. ये हम लोग करेंगे। ये कितने फ्रेश फाइलिंग बच गए?
2 केस।
2 केस बच रहे, कौन कौन है इसमें?
काउंटर।
एक सेकंड।
इसमें हमारा प्रेयर था कि after verification under RTI we have found that 6 marks has not been added to the final result of JPSC.
Yes. Who is appearing for JPSC? WPS number 7402 of 23. Let the counter affidavit be filed in the present case by respondent number 224 by (8th of May), rejoinder if any by 15th of May, post on 12th of June under the heading for recognition. ऐसा नहीं आपका केस इन्फ्रक्चुअस हो जाए, ध्यान दीजिएगा।
Item 35, WPL 1131 of 2024.
Yes, petition. ये क्या फाइल कर दिया?
WPL, Your Lordship.
What is the point of law involved?
My Lord, the point of law involved here is, Your Lordship, that the London Labour Court has directed appointment of the workmen who are 10 in number, along with 20% back wages. They have challenged that, and that they were working as daily wages in the drinking
So what
water.
is the point of law?
My Lord, the main point of law involved is here whether this the drinking water and sanitation department will be considered as treated as an industry or not.
This issue has been decided by this court.
My Lord, that is, the matter is still sub judice before the Supreme Court. There has been a reference made.
Before?
By 5 judges bench, Your Lordship.
Of Honorable Supreme Court?
Only
Of this court?
No, the Supreme Court. So,
Where is the terms of reference? That whether the government employee can be subject matter of...
no, it's on the matter of the definition of industry, Your Lordship. It's on the matter of definition of industry. And yes, this issue is also there that whether a department doing predominantly social survey or
welfare-oriented schemes, whether they will be considered as
Industry.
industry or not.
And this case arises from a similar case that was reference of 6 of 2002, which had been upheld up to Honorable Supreme Court. Case in Reliance, this issue was also contested in that case.
Where are those orders?
Yes, that have been exhibited numbers, they have the annex.
And those aspects have been taken into
Yes,
consideration.
60 pages.
Merely because a reference is made to a larger bench is not a ground to stay this case. And as it is, you see that the stakes of so many people are involved. And then at best you can say that they could have filed a writ petition.
No, they filed a writ, Your Lordship. This case has a lot of facts involved. They first filed a writ, then they were told to file a representation. That representation was dismissed. They again filed a writ. They were told to raise an industry dispute.
So that order has also become final.
My Lord,
So therefore, raising of industrial dispute with regard to this department cannot be questioned as of now.
Yes.
Not only on account of the order passed by this court, but also on account of certain judgments which has been. So you have to show, now the only thing is left is whether there is any perversity in the order. That is all. So you have brought on record everything or something is required?
Everything is on record.
When will you argue?
He had conducted it in the door.
Some exhibits are not there, members. Few exhibits I'll produce.
WPL number 1131 of 2024. Counsel for the parties are present. Let the records be called for from the court concerned. Everybody has appeared? You are on caveat perhaps?
Yes.
Yes. State? State is you are state.
No, I'm
That's
state.
all. कब रखें बताइए?
My Lord, short date because I think there 33 C2 proceedings are going on. I filed an IA proceeding.
I was there last date, madam. He is not, actually he has been transferred. So the seat at present is vacant. It can come on 29th April if my lady so. And if my,
But the records will not come by that time.
yes, because the court has taken into consideration two cases. Case of 6/2002.
No, we'll see that. But those judgments, you have to file your synopsis. It can't be like this.
Yes, I
Right? Let the records come by 8th of May, then we'll see.
Yes.
Post this case on 8th of May 2024. This is fresh filing
Fresh.
under the heading for admission. In the meantime, parties to file their written notes, synopsis, etc. Much prior to the next date.
One IA for early hearing may be closed.
IA for early hearing is closed. Since the date has been fixed, IA for early hearing is closed.